Welcome to the Appellate Division, First Department. We have almost 7 hours of argument time requested today. Therefore, only ask for the time that you need, not the time that you want. We are familiar with the briefs, we are familiar with the records, and if we have further questions, we will keep asking questions even after the time has passed. People versus Chatwin, appellant. Respondent? 5, 1, and 5. 305 Riverside versus DHCR, appellant?
Appellant DHCR request 4 and 2. Respondent request 4.
4, 2, and 4. Sharice versus Perry is submitted. Blackstock versus Acidi, appellant?
Request 5 and 3. Respondent request 5, Your Honor.
5, 2, and 5. Cornejo versus City of New York, appellant?
Appellant, requesting 4 and 2, please, Your Honor.
Respondent?
Respondent, request 4.
4, 2, and 4. People versus Jerome, appellant?
Appellant request 6 and 2, Your Honor.
Respondent?
Respondent asked for 3.
5, 1, and 3. Lexington Associates versus Commissioner of Department of Buildings, appellant?
Appellant request 5 and 2.
Respondent? 5, 2, and 4. Hassan versus Armuth International, appellant?
Yes, appellant request 5 and 2. Respondent request
5, 1, and 4. Queens Rails Corporation versus MTA, appellant?
Appellant request 5 and 1.
Is respondent here? Oh, sorry, okay, I'm sorry. 5, 1, and 5. People versus McGregor, appellant? Respondent? 6, 1, and 6. Elizabeth versus Shaquana is submitted. Law Offices of J. Bacher versus Soffler, appellant?
Appellant Bacher requests 8.
Respondent?
Cross appellant
And cross appellant.
request 5 and 3.
I'll give 5 and 2 and 5 and 2. Garrett versus City of New York. Respondent? 5, 2, and 5. Sales Care versus SEIU, and I know there are 3 parties. Appellant? Is anybody here in that case? Okay, it's submitted. IKB International versus Wells Fargo, appellant?
Appellant request 6 and 2, Your Honor.
Respondent?
8, Your Honor.
6, 2, and 7. People versus Murley, appellant? That case is submitted. Vargas versus Department of Education, appellant?
Appellant request 5 and 2, Your Honor.
Respondent?
2 minutes, Your Honor.
5, 1, and 2. And 16 West Ace versus Gluckman is submitted. The first case will be People versus Chatwin.
Good afternoon, Your Honors. Paris DeYoung of the Legal Aid Society, here on behalf of Appellant Mr. Adam Chatwin. In this case, the prosecution failed to establish that my client surreptitiously recorded the complainant, having presented insufficient evidence that Mr. Chatwin, who actively made the recording in plain view of the complainant, attempted to conceal his conduct or escape detection.
Well, the recording was made in plain view.
Yes.
But was it made under circumstances suggesting maybe that a recording was being surreptitiously? I mean, that the victim did not know about it?
Well, no, Your Honor. The only real question when it comes to surreptitiousness is whether or not the defendant or the person making the recording is acting in a furtive or stealthy manner in doing so. In this case, because the complainant testified not only that he saw my client holding the recording device in front of him.
With the recording, it's a phone.
It was a phone, yes.
And you can use phones for things like looking at email, correct?
You certainly can, Your Honor.
And doesn't that suggest, in fact, that he was holding the phone up to his face, as I understand, pointing it downwards, that it was an attempt really to take a photograph of this man's genitals?
No, Your Honor, because the complainant testified that he really had no idea what my client was doing with the phone during that time. And so it was entirely possible.
Didn't he testify that he did not believe he was taking a picture of him? He had no suspicion or belief that he was being filmed with the phone. Wasn't that his testimony?
No, his testimony was, there was really no conclusive statement he made as to what was going on with the phone. His testimony was that he was holding it.
Defendant's conduct in asking for money in return for the video or not forwarding the video speak of his intent to record surreptitiously?
No, it doesn't. I think there's a lot of corollaries here, but when we look at like revenge porn, for example, laws around that, whether or not the intention at the time of the recording, whether or not that recording is later used for a nefarious purpose, does not speak to whether or not in the moment his actions were furtive or stealthy. That is the only question that needs to be answered here.
So I'm sorry, go ahead.
Isn't the whole way the video was taken, though, some evidence of its can't even say it. It was taken can't say it.
I know,
Surreptitiously. In terms of it being down initially and then moving up as it goes on to capture his face.
Your Honors, again, I think the real question here is whether or not the complainant could readily perceive that there was a recording device pointed in his direction.
It's not a recording device, it's a telephone. It's an iPhone.
Well, it's a smartphone, Your Honor, yes.
Smartphone. So if it were a recording device, I think I would agree with you. It's if it were a camera, for example, that's understandable. But this is a phone that is used for multiple purposes.
It is absolutely used for a multitude of purposes, but the camera was pointed in his direction, and his testimony, again, Your Honors, it was so far from conclusory. He said, it was kind of like, or he was able, or maybe he was looking something up. I couldn't, but it didn't. It was sort of when he was making these statements, I'm kind of getting dressed. I wasn't sure if he was looking up or checking emails or something or texting or the way that people do. It could have been any, but he was fully aware that the recording was a possibility.
Let's go back to the circumstances here.
Sure.
Because how do you account for the fact that the complainant just took so many steps to remain anonymous? Right? He, sent photos of someone else's body parts, used a fake name. I don't have to go into the details, but so many. So how do we deal with that?
Well, those are the complainant's actions, Your Honor, and they're actually completely irrelevant to whether or not my client...
No. Because we have to look at the circumstances. And so when you look at all of that, plus, the email that he sent and said, I want $650, otherwise I'm going to let your wife know about the encounter. So you have to look at everything.
Absolutely, Your Honors, but at least with respect to the complainant's furtive behavior in trying to keep these affairs from his wife, what that would speak to, if any of the elements here, is the lack of knowledge or consent element. And the Court of Appeals has made very clear...
So someone that does everything possible to keep his identity a secret.
That would speak to his lack of knowledge or consent to the video. And the Court of Appeals in Schreier, the Third Department in Pisnarski has made
Why
very
doesn't that also support that he had no idea that any photo was being taken of him, which supports that it was secretive that the photo was being taken of him, that if he wanted to be secretive, he would not have consented to the photo being taken of him. And the fact that it was taken supports that it was taken secretly.
Well, again, Your Honor,
based on the circumstantial evidence in this case.
May I just respond? It's important to remember that these elements, there has to be evidence that establishes both that is separate and distinct. They cannot rely on the evidence that would only speak to knowledge or consent and bootstrap that onto the surreptitiousness element, which is what the prosecution did here.
Thank you. You have time to rebuttal.
May it please the court, Jamie Maston for the people. Your Honors, by hiding his behavior behind unassuming, unsuspecting conduct, such as checking his phone for emails or texting, this defendant was able to use his phone to surreptitiously record the victim's naked body, a video that the defendant later used that same day as leverage to
How much time passed between the time the recording was made and when the first, I think it was by email, was sent out to the victim?
Mere minutes. The agreed upon time for the meeting was around 1 p.m. The victim was out of the defendant's hotel room within 15 to 30 minutes. The first message the defendant sent via Craigslist to the victim was at 1:34 p.m. The victim actually received that message while he was still in the lobby of the defendant's hotel room. So he hadn't even exited the premises before the defendant put into action his extortion attempt of the victim.
Also, is the surreptitious nature of the recording evident in the recording itself?
Absolutely. This video has all the hallmarks of one created with stealth. And this makes sense because if one's goal is to create a compromising video of a victim whom you later intend to blackmail, the jury reasonably inferred that this video had to have been made with stealth. But looking at the footage itself, there are a few key aspects which the jury very clearly saw because they watched the video multiple times during the trial. The first is that this video is 6 seconds long. That's it. It's long enough for the defendant to capture both of their naked genitalia as well as the victim's face. This was just enough to create enough to threaten the victim, but not a second more, because any longer of a video would have risked this defendant getting caught in the act, which he absolutely could not do. Nowhere in the video do we hear the defendant say, "Hey, I'm starting a recording. I'm recording you right now. Hey, you're on camera." That was a secret that the defendant kept very hidden from the victim. And of course, as the jury saw from watching this video, this is not a flirty video. The victim is not performing. The victim is not mugging. These are not two people who are sharing a shared moment together. This is a video of a victim who is standing completely naked in front of the defendant as he balances on one foot to put on his sock. This is a moment in which no one would want to be recorded for posterity, let alone recorded by a stranger on a smartphone. So this video layered perfectly with the victim's testimony, of which he saw the defendant hold his phone in a low manner. He testified very clearly that the defendant was not holding his phone in an unusual manner. And from that, the jury could infer that the defendant was not holding his arm outstretched as if to take a selfie. He was not panning the victim. And the angle at which the video is taken of the victim, again, comports entirely with the victim's testimony that the video was taken from a low angle, as if someone was holding a smartphone against their body in the same manner as anyone would if they were checking email, browsing the internet, or texting.
Counsel, can you tell if someone is holding a phone up, whether the phone is recording at the time?
Not necessarily. There are a myriad of functions on a modern smartphone, and just because someone has pulled out their phone does not mean that that person has opened up the camera function and begun to take a video of someone in a very private and compromising position. And that's exactly what happened here. The defendant tried to conceal his act of recording and escape detection by using unassuming, unsuspecting behavior. And this was calculated because the defendant was trying to create plausible deniability. He knew he could not get caught because, as Justice Kennedy pointed out, this was a victim who was very closely safeguarding his own privacy. By the time this defendant had opened up his camera function, he knew a few things. One, that the victim had described himself as married but totally discreet, thus indicating that the victim may have had a secret that the defendant could later prey upon, that the victim had used a false name, and that the victim had used false photos. So these are all things that told the defendant that he had to use stealth in order to get the leverage for his extortion plan that he needed, and later used as a trump card 2 hours later when the victim was stalling him.
Was the complainant surprised when he got the email from the defendant that he had been actually recorded?
I see that my red light is on. May I
Let me answer the question.
finish my thought? I think it's fair to say that the victim's world was totally shattered. From the very first message at 1:34 p.m. to minutes later when the victim was confronted with his real name, to minutes after that when the victim was confronted with a threat that the defendant was going to tell his wife, to 2 hours later when the defendant finally, after the victim's stalling of not delivering the money as the defendant demanded, sent the video. So I don't think that there's really any clear inference, and certainly none that would imperil the victim's credibility here.
Thank you.
Thank you very much.
Your Honors, I'm not here to say that my client did not commit a crime. He was guilty of extortion, he was convicted of that offense, but he was not guilty of unlawful surveillance in the second degree. What matters here, what the prosecution fails to address, is the fact that none of the factors that they are looking at can overcome the fact that the complainant testified that he saw my client holding a smartphone that did have recording capabilities
But
in
that
front
means
of him.
absolutely nothing. As my colleague already stated, everyone's holding a cell phone all the time. There's no inference that can be drawn from someone else holding a cell phone. There's no inference can be drawn that he was aware he was being taped, because everywhere you look, except in this courtroom, everyone's holding a cell phone.
Respectfully, Your Honors, the prosecution actually concedes in its brief that this was a readily perceivable recording, and they say, respondent's brief.
Argument that you're making that the conduct cannot be surreptitious because the camera was in plain view, hasn't that been rejected by the court?
It absolutely has, Your Honor, but only when it comes to the recording device being perceptible somewhere in the room. That was the Pisnarski case. What is different here is that my client was holding the recording device in plain view of the complainant. In that
Thank you.
case,
Thank you.
thank you.
305 Riverside versus DHCR.
May it please the court, my name is Sandra Joseph. I'm here for the appellant, DHCR. The court below erred in remanding the owner's deregulation.
Can I ask you a question before you even get into the merits?
I'm sorry.
I have a question for you before you get into the
Okay.
merits of the case, which is, what impact is the Court of Appeals impending decisions in the cases of granted leave on going to have on the determination in this case? I know it granted leave both in 160 East 84th Street and Claremont.
Right.
So once it decides those cases, will that impact whatever decision might be made in this case?
Well, those cases primarily dealt with, and even the information statement stated that it was whether it was retroactive or not. In this particular case,
Is that the issue in Claremont?
pardon?
Was that the issue in Claremont?
In what?
Claremont. The other case that went to the Court of Appeals, Claremont. Clermont, Claremont?
Yeah, but this case is a little bit different because actually Arlene Blues found that it was prospective, but the issue was that DHCR didn't adhere to the timelines and that there was a delay in processing the deregulation petitions. So therefore, the reason she remanded it to us, not that it was retroactive, it was simply because we didn't adhere to the timelines in there. So she's saying she actually found that the only reason that the case came about was because we didn't process it timely.
What's incorrect about that decision?
Pardon?
What's incorrect about her analysis? That if you had complied with the timeline, there's no question that these would have, with the statutory time, there's no question these would have been processed before the legislative changes. And the only reason they were not processed was because DHCR didn't comply. So why isn't that valid reasoning on her part?
Because this court has found in two other cases in Claremont and 160 that was just decided in 2022 that unless the owner makes a showing as to DHCR's negligence or delay, that it won't impact. And this court has found that in Partnership 92, in McCarthy, the same thing, that even an 8-year delay doesn't, take away the jurisdiction from DHCR. And also, Even the Court of Appeals in IG second generation found that the delay will not impact will not change the decision.
Did the owner have a remedy when there was delay? There were two petitions filed in this case, correct?
Yes.
What was the remedy that the landlord had?
The landlord could have filed a mandamus petition, which it never did. It never took any steps to say, hey, you haven't processed my petitions. There was no showing whatsoever. And even in their papers, they said there was no show in their respondent's brief. They don't even discuss that, that they made a showing. They just said DHCR didn't adhere to the timelines.
And in other cases, in prior cases where there's been delay from DHCR, which unfortunately seems not to be unusual, have mandamus proceedings been filed in Supreme Court to compel DHCR to make a decision within a statutory time period?
I'm sorry, could you repeat that?
Have mandamus proceedings been filed against DHCR for DHCR to make findings within a timely?
Yes, there in the cases that I cited, the delay, even though there was a delay that were filed against DHCR, in those cases, they found that there was no showing, that the petitioner or the owner has to make a showing that the delay was deliberate, negligent, and in this case, there was no showing.
Thank you.
May it please the court, my name is Jillian Bittner, and I represent the respondent owner in this appeal. Before I begin, I just want to address Justice Kern's point. The 8 appeals that were granted leave to the Court of Appeals could potentially have some bearing on this case. Those cases involve final and binding luxury deregulation orders. The interplay of the enactment of the HSTPA is what is before the Court of Appeals. This case differs from those to the extent that the owner here did not have the benefit of those final orders issued by DHCR because DHCR waited for years to process time.
Let me ask you, going back to the question from my colleague, why couldn't there have been a mandamus proceeding brought to compel DHCR to issue a decision in these cases at an earlier date rather than just sitting by and waiting?
So the mandamus proceeding itself takes time to work its way through the court system. That requires commencing a Supreme Court action. The papers and the rent administrator who's processing the application gets taken away from them. It then goes to the legal department. That has to work its way through the Supreme Court, all because DHCR didn't comply with the statutory mandates that are explicit in rent stabilization law, former rent stabilization law 26504.3. The language in that section uses the word shall, must, within 20 days, within 60 days. As Justice Bluth held.
Well, but I'm sorry, we read Justice Bluth's decision, but going back to what actually happened here, you file a petition, correct?
Yes.
And nothing happens for a year, correct?
You file the luxury deregulation petition and you...
Counsel, you file a petition, nothing happened, correct?
Nothing happened that we were aware of.
Okay, so what did you do then?
The owner was aware of.
What did you do then? You filed a second petition.
We filed the second petition in 2018.
Why not, in those circumstances, rather than filing a second petition, why didn't you move for mandamus relief? Because the statute, you says shall.
Because this had been a custom of DHCR's to delay the processing of these. We have clients that not only this owner, but similarly situated ones where their proceedings were pending for years and ultimately were granted. It wasn't incumbent upon the owner to compel DHCR to act according to its duties and obligations. If I could just, I just want to bring up a point here that I think is rather significant. Since my last argument before this court, which was before Justice Kern and I believe Justice Singh as well, the DHCR has proposed and actually adopted amendments to the Rent Stabilization Code. And I know that this has not been briefed because this just happened November 8th. Implicit in DHCR's adoption of an amendment to the Rent Stabilization Code that permits them to terminate any petitions outstanding on 6/14/19 is the fact that prior to November 8th, the agency didn't possess any authority to do that. The petitions herein were dismissed in 2019. Had they been timely processed, at the latest, the first would have been issued on January 29th, 2018, and the latter would have been adjudicated by January 29th, 2019. So I just want to bring that to the court's attention because at the time that DHCR dismissed both of the petitions, not only had the amendments to the code not been proposed, they had not gone through SAPA and they had not been adopted. So it's clear that the agency's actions were not sanctioned at that time.
I have a question. Let me turn on my microphone. I have a question. So there's no dispute that the delay was, what, over 2 years, something like that? And I'd like to know what evidence did you set forth that the delay was, based upon any willfulness or negligence by DHCR?
The facts on their own set forth that it was at minimum negligent, if not deliberate, because the statute is unambiguous in terms of the processing timeline. The decision by DHCR to not even take the first step, which is to request tenants verify their income or provide information so the Department of Taxation and Finance can verify their income, the fact that even that initial step was not taken in May 2017, that's over 2 years before the HSTPA was enacted, is on its face evidence of negligence.
So it's fair to say that what you just communicated to the bench, that constitutes evidence of their willfulness and negligence?
I would submit that it does.
Okay, thank you.
Thank you.
Thank you very much.
As to the evidence, there was no evidence presented. The respondent has no knowledge how far we processed the application because they never inquired.
Is
DHCR,
delay in itself under our case law,
pardon?
is delay in itself under our case law evidence of negligence?
No. And that again goes to IG second generation. That was decided by the Court of Appeals, McCarthy, and Partnership 92 that says that unless the petitioner shows evidence that it was negligent or deliberate, as this bench noted, they never did anything. They just filed another petition, and as the respondent said, it was customary for DHCR to take years to process these applications, and nobody ever filed a mandamus proceeding.
Thank you very much. Blackstock versus Acidi.
Good afternoon, may it please the court. My name is Cy Aidner for the appellant. A party that provides fuel is responsible to maintain all in-ground appurtenances under a special use theory. The two components to finding special use is access and control. We have both here.
Where's the evidence of access and control? Clearly, they're not the owner. They're not leasing the property. So where does the control, where's your argument for control come from?
Control comes from the testimony from BP's fuel delivery agent, John Ondroff, who said that it is in fact BP who's responsible to repair and maintain the in-ground gas caps. That testimony, of course, is diametric to what BP offers through its corporate designees. But BP's delivery agent himself said it is BP responsible for the subject cap involved. As it relates to access, under the contract, they have 24-hour, 7-day-a-week access to the gas
Where
site
is
with
it?
or without
And there's
notice.
an agreement. There's a supply agreement with the driver, not a supply, an agreement with the transportation company. Where in that agreement does it provide that BP is responsible for maintaining or controlling the gas cap?
It doesn't, but when you look at the testimony concerning what actually happens in the field, according to BP's own delivery agent, it is BP that is responsible. If we were stuck within the four corners of that contract, I would agree. However, the contract is largely irrelevant respectfully when it comes to special use, because this court under Espinoza and Schechtman says, look, who ultimately benefits from the appurtenance?
Espinoza is different than special use. You're talking about special use for a piece of property. That's completely different than Espinoza. That's apples and oranges. I'm not sure what you're referring to.
Well, under Kaufman, Court of Appeals, it said, at least in dicta, that it draws no distinction between public and private property. So the contract is largely irrelevant for the purposes of special use.
I'm not sure I accept that. Why should the contract be largely irrelevant? Because under the contract, the defendants really don't have daily control over the operations of the franchise, correct?
Over the franchise,
And
correct.
isn't that what we look at to see who's that? So that means that it's the franchise is responsible for maintaining the property, et cetera.
That would be relevant, Your Honor, respectfully, for vicarious liability, not whether there's an issue fact over special use. Those two, respectfully, are distinct.
Counsel, I'd like to go back to the testimony regarding, is it Ondroff? Is that how you
believe
pronounce
so,
his
Your Honor.
name? Okay.
Yes, Your Honor.
So supposedly, BP is responsible for the maintenance, as per his testimony. What is that knowledge based on?
His personal experience of being the manager and the representative for the fuel delivery agent retained by BP to deliver fuel for that gas station.
So how do we deal with the fact that I believe he didn't have any personal knowledge of the dealer supply agreement? I mean, that's really what we have to look at. So how do we deal with that? I mean, he says they're responsible, but does he have knowledge about what was in that document?
He doesn't, but under Weingrad, construed in the light most favorable to the non-movement, remember, to meet your burden, you have to eliminate all issues of fact. If BP's fuel delivery agent, the manager for that agent says, at that gas station, it's BP's responsibility to maintain that fuel cap, we're entitled to the presumption.
But the question is, I think that's what my colleague is getting at, is how does he know for a fact that it is BP's responsibility to take care of that gas cap?
I didn't take that deposition, but I can presume from his experience of being a manager responsible for that gas station, I think that's a permissible inference from that deposition testimony.
Presume.
He's presuming.
But again, I'm entitled to the construction of the facts in the light most favorable to the non-movement. And by the way, doesn't that go contrary to both BP corporate designees who said, by the way, we have nothing to do with that cap?
So when we look at the agreement, and the agreement say that it is the owner or the lessor of the gas station, the independent contractor, that is responsible for maintaining, controlling all aspects of the gas station, should we credit what is in that agreement, that they would be the ones responsible for maintaining the gas cap, or should we credit the delivery driver who presumes that it would be BP's responsibility?
Respectfully, you have to look at the totality of the circumstances. I understand that the contract is clear, that it doesn't delineate that responsibility to BP. However, the fuel delivery manager testified based on his experience, and I think that that's competent evidence, construed in the light most favorable to the non-movement, that at least there's an issue of fact over special use. Thank you.
Thank you.
May it please the Court, Patrick J. Riley III, on behalf of Respondents BP America, Inc., BP Corporation North America, Inc., and BP New York, LLC. Respectfully, Your Honors, the issue with this case and the fatal flaw is that the complaint named the wrong location, address of the gas station. This was not discovered until 5 years after the accident, that it was an actual different location.
Can you address the special use argument?
Sure, absolutely. 99.9% of the cases involving special use, when it involves an appurtenance, involves a sidewalk. I could not find one case where a fuel company or otherwise responsible for controlling or maintaining a property on a private property. The case that counsel cites to in Kaufman, the court didn't address private property. That case involved two commercial properties with adjoining properties. And they said, we're not based, said as a matter of law, we're not going to rule that an adjoining property owner that enjoys the benefit of a structure on other property, that can't derive from special use, but based on those facts. The special use here, Your Honor, that, again, this is a private property that are...
You're saying that based on your research, you didn't find any cases that invoke special use when there's not abutting landowners?
Yes. And respectfully, and as Your Honors pointed out, our relationship to this property is a dealer service agreement. The dealer service agreement made clear that the non-party, who is not named in the complaint, were responsible for maintenance and repair and day-to-day operations. We did not reserve the right to go in. We could not show up and make repairs. We didn't have that right because we don't own the property, lease it, or occupy it. There's nothing in the agreement that allows it to show up and dictate how they do that business. Anything the agreement said we were not allowed to as BP. We were just a supply company. Again, the record is clear. The dealer supply agreement speaks for itself. There is no provision. That Section 22 is actually ruled upon in Ramirez in the First Department, and the judge in that case said the right to inspect, when you look at that paragraph 22, it pertains to signage, their products, testing fuelage. It didn't reserve their right to come in and inspect the layout of it because we were not the property owner. Another case later that we cited to was in the First Department, similar, involved with Sunoco. It was very similar. We put back, in our brief, we put back the dealer service agreements. It was the same right to inspect, and the court shot that down. Because the right to inspect doesn't mean you get to step into the shoes of de facto. And as I mentioned, the actual property owner and the actual gas station are not named in this complaint. The fact that BP is the last man standing doesn't mean that we become the de facto owner in this case. The dealer service agreement, and with respect to the BP gas attendant, the gas attendant testified he would report it to the gas attendant, and part of the process he would report it to BP as part of it. That's on page 18. He said, in his opinion, based on hypothetical question, BP was responsible. The last paragraph of that deposition, he was asked, do you know what the scope of responsibility of BP's repairs? No, I do not. And then when it was our turn to ask him, do you know what the agreement was and what the relationship was between the gas operator and BP? No, I don't know. So, I mean, I think, and we said, did anyone at BP ever instruct you that we were responsible for repairs? No, so he has no personal knowledge. At the summary judgment stage, you have to submit admissible evidence. If based on that one line in the deposition transcript, this case gets remanded, the first motion I'm going to file is a motion limited to bar that because he has no personal knowledge and he would never be permitted to testify at trial regarding that because he is not an agent of BP, he is not an employee of BP, and he testified he had no relationship, he had no knowledge of the relationship between BP and the gas dealer. So it's just not admissible. So when you look at the record, when you look at the dealer service agreement, when you look at all the representatives of BP that testified that we are not responsible for maintaining and repairing it, and we never did, we never undertook that duty, then I think the record is clear. And as I mentioned, special use, it just doesn't apply. I mean, all those cases involve sidewalk. There's the one case, again, with the abutting thing, and that was the main argument in their brief, that we have a special use. We merely supply gas, and we did it through an independent contractor that would come, lift up the gas cap, put gas in, and leave. They weren't responsible for inspecting that property. It was not their duty to inspect the property for tripping hazards, things like that. And again, the case law is clear. We have addressed 3 cases in the First Department. Plaintiff's reply doesn't, and the last, before I forget, in the reply brief, apparent authority was raised. The word apparent authority doesn't appear in the complaint. The phrase apparent authority wasn't raised in the underlying briefing. So it wasn't raised, I didn't address it because it wasn't raised in the appellant papers. And regardless, there is no evidence. The apparent argument, the apparent authority argument is just conjecture. There's no citation to the record of plaintiff's testimony.
Thank you.
Thank you.
Thank you. You know, this is the dichotomy between contract and what happens in the field. I understand what the contract says, and I'll concede that it doesn't put gas cap
What about his
on BP.
argument that there's no evidentiary basis whatsoever for that statement that you're relying on, that he didn't have any personal knowledge or any understanding of what the contractual arrangements were between the parties?
He testified, Ondroff testified he had no personal knowledge over the contract, but he didn't say that he was speculating as to what actually happens in that gas station, in the field, in real time, and in real life.
Well, how does he know that?
Because he's the manager for the fuel
Can you
delivery
give
company.
examples of what he saw? Did he ever see BP repair that gas cap? Did he ever testify about seeing them perform any other function that ties into that gas cap?
That's not in the record, but what is in the record is he is
The only
unequivocal.
thing in the record is him saying that BP is responsible without a foundation.
I believe that you can infer that from the fact that he is the manager for that company.
Don't you have
And
to
by-
have some, as my colleague said, don't you have to have some concrete evidence to support his bare-boned allegation? If all you had to say is, I believe it, that's not enough under the law.
I think when you look at his testimony and that answer was unequivocal and it was left at that,
So that's what you're relying
I
on, that he
think-
made the bare bones statement, and that should be enough to raise an issue of fact.
I don't think there's any question about it.
So just going back to the law, did you identify any cases where special use was applied under these circumstances where the person is not either an owner or tenant of the privately owned property?
I'm sorry? I missed
Owner or
that.
tenant?
Well,
Or abutting property
Scheckman, the
owner.
fuel delivery company has a special use with.
No, I'm asking you, are there any cases that say that you can apply special use on private property where the entity is neither the owner or the tenant of that property?
I have to answer that with a yes or no.
Are there cases that say that?
You'd have to put Scheckman and Kaufman together, and that would allow you to have that conclusion. Scheckman gives you special use with respect to the fuel delivery company. Kaufman and Dicta says it's absolutely open with respect to private property.
Thank you.
Happy holidays.
Bonicio versus City of New York.
Good afternoon, Your Honors. Matthew Levy for the Appellant Empire City Subway Company.
Let me ask you a question.
Sure, yeah.
So the whole issue is what work they did there. Nowhere in the affidavit you're relying on does he talk about whether there were any permits for work in that area other than the permit that's being discussed. How do we know, based on that affidavit, how was a prima facie made that there wasn't another permit that was in that site that other work was going on, allowed other work to be going on?
Your Honor, a search was done of the area of the intersection.
Where is that in the record?
It's in the affidavit and the permit.
What paragraph of the affidavit says that you made a search for the permits and there were no other permits? And I'll help you. Go to paragraph 12. I think that's the only place where you talk about permits.
There were other permits that were located for another street that's adjacent to, parallel to the location.
So the question is there an affirmative statement in the affidavit that we made a search for permits and that the only permit we found was the one in the crosswalk?
Well, that was what the research specialist did, Mr. Clements. He did a search of permits.
I understand that's
The
what he did.
question, though, is whether it's somewhere in the affidavit, because part of the prima facie would seem to be a statement that we did a search, this was the only permit we found, and this permit did not provide for any work in the location where the accident occurred, but there doesn't seem to be any statement in this affidavit. Is there any evidence anywhere in the record about the search and what the search did or did not find?
Well, Your Honor,
From any of the parties in terms of whether there are any other open permits?
well, there was a search done, there was a permit that was located for work done on a street that was parallel to this accident location. So it was on Pelham Parkway North. It was not on Bronx and Pelham Parkway.
Is that somewhere in the record, though?
Yes, that was actually discussed by Mr. Clements. There were also additional documents, including the schematics, maps, Google Images. The only work that was done on or behalf of Empire City Subway Company was at that intersection, 500 feet from
I
where
understand
Mr.
that, but where in the affidavit does it say that specifically?
Say what specifically, Your Honor?
That's what your statement you just made, that the only work done was at the crosswalk and on the other side of the crosswalk where the accident occurred.
Well,
We're concerned about 500 feet from the crosswalk. Where does it say that we searched for permits, no permits were found at that location, 500 feet from the crosswalk?
The photographs from the Google Images were discussed, the schematics, the diagrams of the intersection, the 50-foot map, which demonstrates that there was no underground facilities at that location.
I know, but-
going east to west. It was
But
going.
there's two things at play here. There's the underground facilities and then there's permits. So even if we accept your argument about the underground facilities, and I know I'm repeating myself, how can we know, though, from this affidavit that there were no other open permits?
Because with the underground facilities, there was no reason for Empire City Subway Company to do any work at the location of Mr.
Because there
Cornejo's
was no
accident.
underground facilities there? So why were they doing the work on the other lane?
Because on the far left lane in the intersection at the crosswalk, that's where there was work being done. An 8-foot by 5-foot test pit, which was then repaved over about a year before this accident. That's the only
But
work
if
that
there
was done.
wasn't underground facilities there either, according
There-
to your analysis,
there
so why were they
were.
doing work
There
there?
absolutely were, and that's where the location of the underground facilities were. They were going north and south, they were not going east and west, and that was addressed.
So you're saying we should surmise that there would be no work going on where the accident occurred because there's no facilities there, and if there's no facilities, there'd be no reason to have any work.
Because there were no facilities, there's no reason whatsoever for Empire City Subway Company to dig at the
It
location
would
where,
only be digging, so by showing there's no facilities, you're arguing you've made your showing that there was no work.
that's correct, Your Honor.
Okay, thank you.
Thank you, Your Honor.
May it please the court, my name is Nicholas Favanti from Gallo Fatucci & Carr, representing Zebra Technical Services.
Do you have any idea whether there were any other permits in play in this case as to what that could be a basis for an argument that work was being performed at that site?
Well,
by
we
Empire?
we don't know. We only have the word of the affidavit from Mr. Clemens. We would need to depose him and ask him, besides the one location he testified, or his affidavit.
What about his argument that they're only going to be doing work where there are facilities and there are no facilities where the accident occurred? And if they made a prima facie showing that there were no facilities at the site where the accident occurred, why isn't that enough to make a prima facie showing that they weren't doing any work at that site? And you'd have to come back with something to rebut.
I mean, I don't think that was a prima facie showing, but,
Why isn't it a prima facie showing?
well, because he only testified about that one spot. He didn't testify that he spoke to anyone who actually did the
Well,
work.
he testified that the only facilities of Empire was running not where the work occurred. It was running east-west and not on that road. So why is that not sufficient to establish no work was being done where the accident occurred?
I mean, I agree with you that that's what it was testified to, but that doesn't mean that's where the work actually occurred.
How about in paragraph 13, Mr. Clements says, it's a little conclusory, but it's indisputable that ECSC has no facilities or conduit and perform no work at the location where plaintiff asserted that the decedent lost control of the motorcycle. So what about that? Is that sufficient to make out the prima facie?
I don't believe that is.
Why?
Are you only, I'm sorry.
Why?
Again, because it doesn't show that the work was actually done, only that there was no facilities at that place. He had no
Is that your
knowledge.
only argument? That's what, I'm sorry, I interrupted, but that's what I'm trying to get at. Is your only argument that they haven't sufficiently established what they say and that you need discovery to determine that what they say is correct? That's your argument?
Yes, absolutely.
Okay, so you're not saying that they didn't make a prima facie, you're just saying that even if you made your prima facie, we have a right to conduct further discovery to find out if what you're saying is really true.
Well, the lower court did say there was no prima facie case made.
So I'm asking what your argument is. The plaintiff isn't here, so you're the one arguing.
Yes, I understand. I mean,
What is your argument exactly?
my argument is that he had no personal knowledge of the work that was done. He only looked into the records. He did not know whether.
Well, I don't accept that argument that because he's a custodian of the records and he's an expert, he's doing that. So the question is it your position that a prima facie case was made out on this affidavit, yes or no?
No.
Why not?
Again, I don't want to keep repeating myself, but I believe
Because he doesn't have personal knowledge.
Yes.
That's why you think okay.
yes. And also, just mention that we believe we are entitled to further discovery to see if there's any other permits or other work not in the records.
The affidavit doesn't specifically say that there were no permits for the location where the decedent lost control of the motorcycle.
Yes.
But is it a fair inference based on the statement that since we didn't have facilities at that location, which is what is said, that there would be no reason to dig or whatever they do?
Again, it could have been a mistake by the crew or any other reason that they did work in that area. We know there was work done in the vicinity, and we believe we should be entitled to more discovery regarding that area before summary judgment closes off that possibility.
Thank you.
Thank you.
The argument that the records person at Empire City Subway Company doesn't have personal knowledge of the actual work that was done or wasn't actually at the scene when the work was done is in my opinion, is insufficient
Well, it's also not consistent with our case law, but the question is wouldn't it have been better, it's supposed to be a bad way to start a question, to have said, hey, we look for permits at the place where the decedent lost control of the motorcycle, there were no permits. Wouldn't that be an open and shut prima facie at that point?
Well, Judge, he was reliant on not just the permit search that was done at the intersection, but also the schematics and the diagrams and the Google images and
Where does he
the
say that he
maps.
was relying on all those maps and reaching his
Well,
conclusion?
those were the exhibits that were
I'm just
attached.
asking you, in the affidavit, where does he say what you're just saying? He doesn't say that.
well-
You're asking us to assume that.
It was part of his investigation, and then there were various exhibits
Where does
attached.
he say that he was relying on maps, 50-foot mat, all that? Where does he say that?
Well, does he use those exact words? No. However, Your Honor, he does provide various exhibits. There are 7 exhibits that are attached to his affidavit that form the basis of his opinion.
Thank you.
Thank you.
People versus Jerome?
Good afternoon, and may it please the court. I'm Liza Batkin from the Legal Aid Society, representing appellant Jerome Hancock. We are asking this court to reduce his youthful offender adjudication to second-degree robbery because a guilty plea to first-degree robbery was invalid.
Do we have the authority to do that?
You do. For one thing, this court has granted this relief before, modifying first-degree robbery to second-degree robbery, even upon a guilty plea.
What was our authority to do that?
CPL 470.15.1 grants this court a broad grant of power to modify a judgment. It lists numerous ways in which this court can modify a judgment, but the statute makes clear that the court is not limited to those ways of modifying a judgment. I would also point out, as I submitted as an additional citation yesterday, and I have copies for the court, this court last year in People versus Perez modified a conviction from third-degree assault to second-degree
Well,
assault.
wasn't that case distinguishable in terms of its facts, that there was really a good faith effort to comply with the conditions, and the court essentially found that the defendant did what she could, I think, to comply, and she couldn't comply, and that was the basis for the modification, correct?
Well, the merits of the case may have been different, but in terms of whether it does suggest that this court saw itself as empowered to grant a modification of a judgment based on what happened in that case. And they did that without the people's consent, and they did it in the interest of justice.
Doesn't Garrett say something different than what you're saying?
Which case, Your Honor?
Garrett.
I'm not sure I'm familiar.
Oh, I'm sorry. Maybe I have the wrong case. Hold on a sec.
You could go on with your argument.
Okay, thank you. But just to return to the merits of this case, at the start of the plea allocution, the court stated on the record that it had come to its attention that what had been displayed during the robbery that Mr. Hancock was pleading to was actually a BB gun.
Can we walk through that? It seems my reading of the transcript is that at the time that that statement was made by the lower court, it was when she was considering a plea to count 1.
That's right, Your Honor.
And then there was a sidebar, which is not transcribed. Is that correct?
Yes, that's right, Your
After
Honor.
that sidebar, the plea to count 1 was withdrawn and instead replaced with count 14.
Yes.
Now, after that, we don't know what happened at that sidebar, but something in that sidebar triggered a change in plea from count 1 to count 14. Is that right?
Yes, yes.
Now, in terms of the BB gun, it was co-defendant Collins that had the BB gun, correct?
No, Your Honor. That is not at all established in the record.
So how do you establish the BB gun to count 14?
What I know from the record is...
My question is, how do you establish the BB gun to count 14? Because from the record, my reading of it, Collins, the BB gun was recovered from co-defendant Collins. He admitted that he had possession of the BB gun, and Collins was not involved in count 14. He was not charged in count 14.
To be clear, the record does not establish that the BB gun was recovered on Mr. Collins. I'll leave it to my my opponent to explain where in the record that comes
Right,
from.
so if that is the case, then I'm giving you the opportunity to tell me, how do you connect the BB gun to count 14?
Okay, the reason that the way that the BB gun is connected is that the court raises the fact that it was a BB gun, and it is upon that fact, there's no sidebar at
Right,
that
as it
point.
relates to count 1.
Well, yes, but then the DA never objects to the same deal being applied to count 14.
Presumably because the BB gun is not connected to 14.
Well, no, because it was in fact the presence of the BB gun that motivated the court at the beginning of the allocution to grant a much more favorable plea than the plea that
There's
the people
several
were
robberies
seeking.
involved here, correct?
There were several robberies that were indicted, yes.
Yeah, and he pled guilty to the one on June 8th, correct?
That's correct.
Collins was involved in the robbery on June 10th, correct?
Yes.
All right, I have nothing else.
But to be clear, there is nowhere in the record that establishes that it was Mr. Collins who had the BB gun. Again, I'll leave it to my opponent to explain where he gets that information. What we know is that the court identified on the record that the weapon used in the robbery was a BB gun. The people never contested that fact. They didn't object at the time, even though it caused the court to
When it says,
modify.
when the court was referring that the BB gun was used in the robbery, singular, is it possible that it was referring to the robbery on the count 1?
I have to assume that if it was referring to a robbery that was entirely different from the robbery to which Mr. Hancock was pleading, the people
Well,
would
at
have
that
objected.
time, at that time, the offer was to plead to count 1, wasn't it?
Yes,
And then there's a sidebar, and he pleads to count 14.
but once the offer changed to count 14, the plea deal never changed. There was no objection that now that it was count 14, in fact, he didn't deserve the more lenient.
What was the reason to change from count 1 to count 14?
That's not on the record, Your Honor.
That's the million-dollar question.
Say it again?
That's the million-dollar question, isn't it?
Yeah.
Thank you.
Thank you.
Do you have any more questions?
Good afternoon, Your Honors. May it please the Court. Elliot Robert Hamilton for the Office of the Bronx District Attorney. Your Honor, the reason why that's not on the record is that there were no motions filed pursuant to CPL 220.60 subsection 3 or 440.10 trying to outline any of this stuff on the record. Everything here is speculative. Everything here is unpreserved. With respect to the BB gun was the mention of the BB gun from Collins was actually in the indictment in the voluntary disclosure form in the statement that Mr. Collins ended up saying that he ended up having a BB gun in his possession, which, again, as Your Honor pointed out, this all occurred on June 10th. The count in which the defendant pled guilty to was on June 8th. There is a lot of attenuation between the 10th and the 8th, so we have no idea whether the BB gun alleged that was seized from Collins on the 10th was used on the 8th. And to the court's credit, they mentioned the BB gun only for the purposes of looking at the mitigating factors that allowed the court to give the only offer that the court was allowed to give the defendant over the people's objection. The people wanted the defendant to plead guilty to a D nonviolent with a year determinant and no youthful offender treatment. And upon looking at the PPI and looking at the fact that there was a BB gun, the judge made statements prior to the plea colloquy that outlined all the mitigation that allowed her to say on the record why she was going to give this defendant a windfall despite committing 3 gunpoint robberies at 18 years old within a period of 5 days. A treatment plea that he received and he summarily failed, resulting in him still getting youthful offender treatment anyway. The only way in which this court would use its interest of justice jurisdiction to modify this is if it would be with the people's consent. Absent our consent.
What cases support that? I misspoke and I said Garrett, but Wallace, does Wallace support your position?
It's not Wallace that supports that particular position. It's more People v. Farrar. People v. Farrar holds that the people need to have the opportunity to withdraw their consent from a lesser included plea, and if the court were to use its interest of justice jurisdiction to have the defendant instead plead to second-degree robbery, it would violate the separation of powers. And if there are no further questions, the people hold that the claim is unpreserved, it is otherwise meritless, the Lopez exception doesn't apply, and we take no position as to point 2. We ask that you affirm the judgment.
Thank you.
I have 2 quick points to
Actually,
make.
counsel, before you make your points,
Yes.
the court during the plea colloquy says, quote, "I was told that the gun that was alleged to have been used in the robbery was a BB gun, or at least a BB gun was recovered from the co-defendant." What's the impact of that statement?
The impact of that statement is that once the court made that statement on the record, our argument is that under People versus Lopez, it obligated the court to conduct an inquiry to make sure that Mr. Hancock understood that he might have been able to raise an affirmative defense.
Does it matter whether it was on count 1, counts have been changed, is count 14? But why? Why?
Well, I think the count 1 and the count 14 is, the problem is that Mr. Hancock was given the impression from the fact that the court put it on the record that the weapon used was a BB gun, and then the court proceeded to take a plea without explaining that that fact could have entitled him to an affirmative defense. The court therefore misleadingly gave the impression that there was no defense raised by that fact and that there was no problem with the plea.
Thank you.
Okay, thank you, Your Honor.
Lexington Association versus Commissioner of Department of Buildings.
Good afternoon, Your Honors. May it please the court. My name is Mason Barney. I represent the appellants in this action. This action concerns the stability of the law. The question is whether a city agency, when it determines the meaning of a certificate of occupancy through a quasi-judicial process, can then go back and retry the whole matter again in order to get a different.
So you're hanging your argument on Lexington's certificate of occupancy?
Yes, Your Honor.
Okay, so where in that certificate of occupancy does it expressly say that it's for Class B occupancy?
The certificate, as the Oath Board found in 2016, the certificate of occupancy references the alteration application. And the alteration application specifically says that it is being altered in order to create Class B SROs. And so this—
But shouldn't the C of O govern as opposed to what you say in your self-serving alteration application?
The C of O certainly does govern, and that's the point behind the city charter provision. But the issue is the C of O actually references the alt. It references it by number.
What about the opposing point, which is that the C of O specifically refers to an old law tenement, and a tenement has always in the MDL been a Class A multiple dwelling. It's never been a Class B multiple dwelling. So just by use of the word tenement in C of O, it's indicating that it's a Class A rather than Class B.
Well, at the time when the C of O was issued in 1940, it was a very brief window of time, 1940 to 1946. Section 248(1) of the MDL allowed
Go ahead, finish your answer.
Allowed Class B buildings to have a few Class A apartments in it. And the way at the time that the DOB determined what classification was based on the majority of the rooms. Here, 8 apartments, 103 SROs, Class B SROs, which is what was on the alteration application. Clearly, the majority is the Class B, and that's what the 2016 Oath Board found.
Are you asking us for the alteration agreement to trump the C of O, which makes no reference to Class B buildings?
We're not saying—
It only makes reference to tenement, which is a Class A multiple dwelling.
We're not saying that it trumps the C of O. We're saying that everything needs to be read in together because one references the other. Just like you wouldn't read a contract, well, this contract references this piece, this contract references that piece. You read them together. You don't read them separately.
How are you contending then with Terra Lee, which is a pretty broad decision in terms of its applicability and says no grandfathering, no rights, we're not going to allow it.
Absolutely, but we're not basing our claims on grandfathering at all. We're basing our claims on the CO.
We should find it's a Class B.
We should find that it's Class B because the CO references the alt, and the alt said—
The only way to accept your argument that it's Class B, based on what I'm hearing, is that if we accept that the alteration agreement's reference to Class B is controlling.
Not just that, Your Honor. It's also because under Section 248, as I said, in 1940, they were allowed to have both classifications, Class B SROs with some Class A permanent apartment.
But didn't the PAC law at that time still require compliance with the provisions concerning Class A multiple dwellings prior to conversion? So if the answer is yes, right?
Yes.
Doesn't that suggest that we should be looking at Class A as opposed to Class B? That it wasn't converted to Class B, you got to comply with Class A, the Class A provisions.
That would be the case if the alt didn't reference Class B.
But you're relying on the PAC law, and I'm looking at the language of the PAC law in front of me. It allows conversion into SROs, quote, but such Class A multiple dwelling or such portions of being so used shall comply and conform to such provisions as this chapter as are applicable to such Class A multiple dwellings. So nothing in the PAC law said we're going to change it from a Class A to a Class B or allow a permanent change from Class A to Class B. It said to the contrary.
Respectfully, Your Honor, the only reference to the class law, to the PAC law, and I'm not relying on it, the only reference are the two words PAC bill on the alteration application. There are other sections of the MDL that allow...
The PAC law is the basis for you to be able to make the conversion or the application for the conversion, correct?
May I respond, Your Honor?
Yes.
I would disagree with that because other provisions of the MDL did allow for conversion from Class A to Class B.
Thank you.
May it please the court, Antonella Carlin for the city respondents. I think maybe we should clarify a few things. So this clearly was a Class A building, a tenement. Tenements
Before
are
the
always,
PAC law.
yes, always Class A. It's the classification of tenements, always has been. This is an old law tenement. Then they chopped everything up into SROs, illegal. In order to bring the building into compliance with the PAC law, they had to get a new certificate of occupancy.
What about their primary argument that something about the alteration agreement allowed them, because it made reference to Class B, allowed them to change the building partially into a Class
Yeah, so I think a few things. It might have just been a mistake, I don't know, but I think the key here is in Tara Lee, it was very similar, identical certificate of occupancy. They also had an apartment and SROs. They also made this argument that, the tenement applies only to the apartment, SRO applies to the single room occupancies, which are for Class B use because we've been using them for Class B use. There's an alteration application and there's I-cards that say this. And this court squarely rejected that.
Was there an alteration agreement that referenced Class B in Tara Lee, do you know?
To be honest, I don't remember
it's not on the
exactly what
record,
I
Nor is it in
worked
the
on the
decision,
case,
so.
and I don't remember exactly what the alteration, but I think that they were designated as Class B sleeping rooms in the I-card and maybe in the alteration application. But basically, the alteration application gives the layout. So you're changing it from 8 apartments or 16 apartments to 103, SRO rooms and 8 apartments, and it gives the layout. And whatever you want to call it, I don't think it necessarily matters. It's an old law tenement, which is always a Class A building.
That's the definition of an old law tenement,
Exactly.
right? It's a Class A building.
Right.
So the fact that the CFO referred to it as an old tenement building, it was referring to it
Yeah,
as a Class A.
and I'll also just say, if this is a Class B building, as I think maybe they're suggesting, that raises a whole host of issues because you have to comply with a whole set of regulations that...
What about res judicata and that there were prior determinations that expressly went the other way? Why shouldn't res judicata apply in this case?
So it never applies when there's been a change in the law, and I think Tara Lee kind of started that change, and then the ECB following Tara Lee, 7 cases with tenement buildings that converted under the PAC law. Every single one, they have held that it can't be used for transient use, and in fact, in the ECB Tara Lee decision after this case, the ECB specifically said Class B SRO use in a tenement is no longer authorized under the First Department's decision in Tara Lee. And that's exactly what they're saying they're authorized to do. I mean, the ECB overruled that decision and it's not entitled to any preclusive effect. If there are any other questions?
Thank you.
First, just on the question asked about the Tara Lee alt, it did not say Class B. Nothing on the Tara Lee alt said Class B. Tara Lee was relying on a 1947 I-card and saying that that overruled the 1967.
How do you overcome, and I already asked this question, but I'll ask it again, because how do you overcome, even if it said Class B in the alteration, the fact that it's referred to as a tenement in the C of O?
A tenement is, the tenement definition says all or part of a building. And in 1940, again, you could have both Class A and Class B.
Can you now? Does the law allow for that now?
It doesn't, but what the CO says needs to be determined when it was written, not by what someone else later said.
And what
That's
about the fact
point
that
of the
every
charter
court
provision.
that's deciding the issue you're raising is going the other way now? That none of the decisions are allowing what you're asking us to allow?
Respectfully, it's not going the other way because we are saying that this is a Class B building.
You're saying your case is different than every other case because you have this alteration agreement, which refers
As far
to
as I
Class B, and
know-
that's what distinguishes it from every other case, even though it was converted under the PAC law, even though the C of O refers to tenement, and even though the C of O makes no mention of Class B, that the alteration agreement trumps everything.
That the Alteration Act doesn't trump everything, but yes, you're right. It is unique. In 10 years of litigating this,
Is there a case that supports that position, that we should look to the alteration agreement in conjunction with the C of O, putting aside all the issues that we've discussed now? Any cases that support that position?
no, because Your Honor, in 10 years of litigating this case, I don't think the Department of Buildings has ever shown us a alt like the one that we have.
And in fact, don't the cases, for example, the City of New York case versus 330, say, where we looked at a new tenement, single-room occupancy, and we said, by implication, it was a Class A multiple dwelling, correct?
May I finish?
You can answer the question.
In that, my understanding is in that case, the alt is dissimilar from the situation we have before us.
Thank you.
Thank you.
Hassan versus Armuth International.
Good afternoon. May it please the court, I'm Jason Michel, representing Appellant Armuth International, Inc. This appeal is based on the denial of my client's motion to amend its answer and counterclaim, as well as the granting of respondent's cross motion to strike our original.
I'm going to ask you, before we get to the merits of it, to address an argument of the court's jurisdiction to hear this appeal. Since the time that these decisions were issued, the trial court has issued a final judgment in this case.
That's correct.
And although sometimes a final judgment does bring some things up from below, this is not the kind of determination that would be brought up as part of the final judgment. So what authority do we have now to hear this case in the absence of an appeal from the final judgment, which obviously has not been perfected yet?
So what has happened here is we've done some motion practice since this appeal was filed. Originally, I had filed a motion that was met with a cross motion to dismiss
Let me
this
ask you
appeal.
about that, because I know the cross motion to dismiss was denied because at that point the final judgment had not been
Correct.
finalized. That was the reason.
Correct.
So we weren't rejecting what I'm saying here. We were just saying it's premature because there was no final judgment yet. But now there is a final judgment.
Right, so-
isn't the remedy now, rather than getting a determination on this appeal, is to appeal from the final judgment and bring up whatever arguments you have in that appeal?
I don't disagree. What happened then was I brought a motion to consolidate the two appeals, which is presently before the panel. I brought that a couple of weeks ago.
But that would have delayed. Go ahead.
Well, so the reason to bring the
Could have
motion to
been denied for
consolidate.
reasons other than this argument is incorrect.
Correct, but the
Since I'm
reason.
the one who denied the motion, so I'm me what my reasoning was.
Right. So the reason to bring the motion to consolidate is simply because we wanted the panel to hear everything at once. There's
You
now
wanted to stay everything. Part of your application was to stay the judgment as part of your application to consolidate.
It was actually, no, the motion was to stay this oral argument in order to consolidate, and then we would be able to argue everything at once the
You
final
weren't
judgment
seeking to
appeal
stay
was
the judgment as
perfected.
part of it? Enforcement of the judgment?
Well, we've already asked the lower court to stay the judgment, and that didn't happen.
But wasn't that part of your application?
It was not part of the application. I mean, in order to, stay the enforcement of a judgment, the CPLR provides that my client would have to post a security bond. So we weren't basing it on that. It was to stay this actual argument because we wanted to argue everything at once, both this major issue regarding what we believe is an abuse of discretion for not allowing us to amend our appeal, as well as granting a motion to strike a pleading, which is a drastic remedy when the law, the First Department has ruled on this, that a lesser sanction, if there's an issue of spoliation of evidence, should be an adverse inference that would be sent to the trier of fact to the jury. So we, that's what the base.
Discretionary decision, counsel? Isn't that a discretionary decision of the court?
Yes, and that's why we're arguing that that the lower court abused their discretion, because to strike something based on, and we're also claiming that there wasn't spoliation of evidence. This whole issue is surrounding the fact that we had filed a request to so order a subpoena from a third party. It was my client's business partner who received the defective apparel from my client, who had got it from respondent. The court did not so order the subpoena. It was sitting there. So then I ended up in discussions with the third party's attorneys. We discussed it. Then I served them the subpoena. And it wasn't until the motions were filed to strike the answer and for us to leave to amend, that's when we finally got a response from the third party objecting to all of the requests. And so my point is that I believe the court abuses discretion because the evidence that the court wants to see, we can get from another source. And the court is not allowing us to pursue that. And I believe that given the fact that, 3025B, leave shall be freely given upon such terms as may be just to amend a pleading, given the fact that the lesser sanction from a number of First Department cases is much more appropriate than striking a pleading, we believe that it was an abuse of discretion. There was
Thank you.
You're welcome.
You have time for rebuttal.
May it please the court, my name is Jonathan Stein. I represent the plaintiff, respondent. You're exactly right. Under matter of AHO, very seminal case of the Court of Appeals, all prior appeals are subsumed into an appeal of a prior judgment. And what this court would theoretically do is dismiss this appeal in favor of the appeal from the final judgment.
Can these issues be heard on the...
They've been preserved to the extent that he filed an appeal from here. If he hadn't perfected it, I'm sorry, go ahead.
My question is, can they be heard again on the appeal of the final judgment? Will these issues be raised again?
He can certainly try. He hasn't perfected that appeal, so I don't know what his intention is, to be honest with you.
She's asking whether he'd be allowed to, I think. Is there any
That's
bar
really up
to
to the
them being
discretion of this
brought
court. He may have lost that opportunity by doing what he did in this appeal, by pushing forward with this appeal rather than withdrawing it, which he might have had leave to do. And he's also defective, as I said, pointed out in our papers, he defectively perfected this appeal. The informational statement, which is mandated by all four departments, has been in effect for about 3.5 years already, maybe even more, and it just wasn't part of his original filing, and I believe that's jurisdictional as well. He also, by the way, added papers from a subsequent motion in this. But in terms of his claim of abuse of discretion, we cited the case Ben Trading against Shirley Imports. I'm intimately familiar with that case, which which went to the appellate division, this court as well, because I handled it in both the lower court before Justice Lowe and when it came up to the appeal. And like that case, that case dealt with multiple violations of discovery orders. It wasn't just one discovery order that was abused here. It was multiple orders. And yes, the court had the discretion to strike the counterclaim. It actually would have had the discretion to strike the claim as well, the main defenses, which is what the court in Ben Trading did. And this court affirmed the granting, the striking of the answer and the granting of judgment. The fact is that this is, I'm sorry, the excuse is here, and he does have a spoliation claim. That, pardon the expression, we lost it. The dog peed on my homework type of excuse. You know that you're going to have to prosecute.
That's the idiom, Counselor.
I'm sorry?
I don't think that's the.
Well, we lost the documents when we were moving. Well, that's interesting. You didn't lose them to the extent of being able to assert counterclaims with the dates associated with all of the activity in the counterclaim. Yet when it came to document production, they were not producing it. Anyone has any further questions? Otherwise, I've said what I need to say, Your Honor.
Thank you.
Thank you.
Just very quickly, the law is clear that if this appeal were to be dismissed, that this court would absolutely be able to hear all of the issues that are being brought up today. Everything would be.
Well, those that are necessarily affected.
Right, and this is absolutely. And
that is not something then you would argue, and if we do dismiss it, that's what you would argue.
Right, you still have the right to make these arguments in the appeal from the.
Yes, absolutely. And the reason behind the motion to consolidate was not just to have everything heard together, but my client and their client, you've spent a lot of costs with doing the briefs and to then reset and then start over just for judicial economy. I would hope that you would consider the consolidation so that the brief that we would write you can just combine with this. But whatever the court wants, I would just say that in terms of what a respondent's attorney mentioned about the informational statement, it was a minor error and it was filed in initializing this appeal. It was inadvertently left out in the lower court's notice of appeal, and. And that it's a minor mistake. And as far as
no, your time's up. I'm just going to let you finish that thought. Thank you.
Thank you, Your Honor.
Queens Rail Corporation versus MTA.
Good afternoon. Cameron McDonald for the Appellate, Queens Rail Corporation. This is a matter arising out of Article 78 proceeding relating to a Freedom of Information law request with two errors that we'd like to address relating to two categories of documents. The first relates to, there were three subsections of a Freedom of Information law request that related to proposals to be done for work to be done by consultant to the MTA, a proposal and a revised proposal, and then the work product that was produced under the terms of the contract that was entered into for the engineering studies and the testing and all the work that was done to come up with the final product. The lower court accepted MTA's exception to producing the proposals in their entirety without redactions on the basis that they contain trade secrets and confidential business information that would harm the business.
Why hasn't MTA established that production of this information is not permitted because it is confidential information in terms of if the competitor got the cost calculations from Sistra, it would then be able to use that information to either undercut or raise its own bid, and that would cause competitive injury to Sistra, which is an exception to FOIA.
So what Your Honor is referring to would be as if the bidding was in progress on that particular contract and the person
Right, but
could
one
get
contract impacts another contract. These are similar type of contracts. As it's undisputed, there's a small group of entities that bid on these type of contracts, and they've credibly argued that having this information on one contract would affect their ability to bid on future contracts and undercut their ability to bid competitively on future contracts, since it's going to be the same group of entities bidding in the future.
So I'm going to push back a little bit on how much evidence there actually is on how confidential all this
That's what you need
information
to
is,
do to
and
undercut it,
take issue with that. And I'm also going to say that's the cost of doing business with a public entity. We have public
Well, no,
bidding
you still have to
requirements.
get around, we have to put this in the context of FOIL. So it's not a cost of doing business that you have to disclose confidential information. If MTA has sufficiently established that this is confidential information, then it's not a cost of business to disclose it. You have to tell us, and I want you to tell us, why this information is not confidential.
Sure. So we're talking about the types of people who are working on projects, the hours to be worked on projects, what was going to get charged on those projects. These are not trade secrets, I think.
Well, again, how are you responding to my first initial question, which is that if a competitor has just the information you described, it will assist them in undercutting Sistra's bid, causing competitive injury to Sistra.
All right, so any undercutting of a bid would be in some far-off subsequent project with completely different parameters, completely different requirements, and possibly completely different bidders. This is not affecting this particular contractual process. This would be something, you're talking about almost two different things, and that's the case of any sort of public bidding on any sort of contract with any agency in the state. And there is a requirement of public bidding for the taxpayers, the people, to be able to evaluate how the bids were evaluated, whether they're getting the best costs and so on. And so just to be able to say there's only a handful of companies that do these types of things, there's only a handful of companies that do all sorts of things with the state, and that would be a sort of an ironclad rule that would prohibit the public from ever being able to evaluate what actually went into proposals in answering a request for proposals. Then the second error is that the judge didn't even look at and address the question of the engineering papers and the work product that was produced under the contract. MTA has subsequently said, well, we don't possess those records, but it's very clear under FOIL that records produced for an agency are public entities.
What's the remedy for that portion of your argument? What should we do with that?
Order those records produced, disclosed.
Well, but just disclosed without an in-camera inspection to see whether there's cost information or other privileged or business information?
Well, that's the work product that was done under the contract, so that would not be, that's not invoices, they produce invoices that are 10,000 feet. What we're talking about are engineering reports, drawings, studies, facts and data. And they've waived any argument on that because they didn't assert that anything like that was confidential information. They did say it was inter or intra-agency records, but that's just not the case.
Right, so inter-agency exception, well, I'll let you rebuttal. Go ahead.
May it please the court, I'm James Aliaga from Calcutta Law for the respondent and TA. Firstly, your honors, I want to pick up on a point that my colleague mentioned regarding public bidding. Our brief goes into explicit detail and cites several cases to show that a lot of this argument around public bidding, the cost of doing business, is focusing on the wrong FOIL exemption, 87 sub 2 sub C. We cite a case in our brief, Verizon New York Inc. v. Bradbury, from the second department, but it is educational here as to the dynamic between these two exemptions. The opinion just mentions that these exemptions primarily protect different interests that are not incompatible and may at times overlap. However, that opinion goes on to describe that 2C, which a lot of the cases that petitioner cites in their papers regarding public bidding, that FOIL exemption, quote, primarily protects the interests of an agency in achieving the optimum result in awarding a contract to a supplier of goods or services. So it's about protecting the interests of the agency. A separate exemption, one of the main exemptions.
Let me ask you a specific question before we run out of time, because it's a genuine question that I have. Not that all the questions aren't genuine. As to the request for work product,
yes, Your Honor.
Clearly MTA should have that because the contract with Sistra requires Sistra to provide the work product to MTA as part of the contract. So And I know that MTA is relying on an intra-agency exception to not produce those documents, but there's exemption, not exception, but there's an exception to that for statistical or factual tabulations or data. And how have you established in your papers that at least some of those work product documents are statistical or factual tabulations or data, which would not be exempt and which you have to produce? How have you made that showing in your papers?
Well, Your Honor, on the first part of that question about what the contract shows, that goes to the argument that MTA is in possession of certain work product. Number one, in the reply, they bring up contract language. They mentioned that contract is not even in the record. That contract is quoted in the administrative process. The petitioner mentions it in their in the administrative process, but that actual contract is not in the record. So appealing to that language, we would say first the argument is waived. But secondly,
So why would it even bring up if you don't have any documents, why do you even need to bring up the interagency?
Exactly. So that exemption is towards the drafts of the actual deliverable, the actual work product that was produced, the RFP, and the study. I'm sorry.
But how can we be assured that the work product doesn't contain the factual tabulations, statistical data, without, for example, an in-camera inspection?
That'd be a very compelling case for in-camera inspection, Your Honors. However, crucially, the petitioner did not ask for that work product in their FOIL request. At the beginning of his comments, he mentioned that they were looking for certain types of drawings and certain types of CISRA work product that was common sense, I think he calls in his papers. But the actual FOIL request itself does not ask for CISRA's work product. It uses the words complete work product, but then it goes on.
They use the words what?
It uses the words complete work product, but then it qualifies that request by saying the complete work product as produced under the contract, and then says, I think, as produced under the terms of the service order. And what that means is that
why wouldn't a reasonable person construe that to mean work product?
Because if you read the TSOW, that states that the only product that's going to be delivered to the MTA is the final study itself. And so MTA correctly interpreted that, and so did the lower court, that what petitioner was seeking in his FOIL request was the final study and perhaps any drafts of that final study. And that's why MTA responded from the very beginning at the administrative level, stating you can have the final work study, the drafts are under the intra-agency exemption. As the case moved on, as we describe in our papers, the FOIL request morphs. Now he's looking for the complete work product, including engineerings and schematics. And at this point—
What was the exact language in the FOIL request?
Briefly, Your Honor.
Can you point me to the page in the record that has that?
I'm sorry?
Can you point me to the page in the record that has that?
Yes, Your Honor, I believe we could, but I'll read it out for you to make the point that request number 3 was CISRA's complete work product produced under the terms of this contract as per the technical scope of work. And so if you look at the lower court's ruling and another ruling for the motion to re-argue, which we submit as part of the judicial record, the court interpreted that the same way the MTA did, and that's the reason that this administrative record right now, it's not appropriate for going into all of CISRA's work product, because CISRA never understood it that way, neither did the MTA. And I see my time is up.
Okay, I have a question, and I apologize for asking a question over the red light. So in other words, you want them to file another FOIL request, and we start this process again? I mean, does that make sense?
Your Honor, it comes down to how FOIL works, and at this point, as unattractive as that seems, that would be delaying, the alternative is much worse, because we enter a situation where a petitioner can submit a FOIL request, and as they see the process unfolding at the appellate level, at the Supreme Court level, start playing definitional games and leaving this court to decide, well, does work product, which is a term of art under FOIL, is that applicable to CISRA's work product on this record that is not fully developed yet? And for that reason, we don't believe that question should be reached at this case.
Thank you.
Thank you.
If you could respond specifically to this issue as to what your FOIL request, as to work product did or did not request, and the argument by the MTA that it was really a much more narrow request than a request for all work product.
So the reference in the record is volume 1, page 22. for where the request is. In the subsequent pages to that, there is the actual administrative record that was under review at the Supreme Court, which is what went on back and forth between the Records Access Officer and the Records Appeals Officer, where my client quoted the standard term of the MTA contract, which is throughout all the papers in the record. It's referred to as their standard contract. And what we're talking about is we're talking about a hyper-technical, lawyerly interpretation of something submitted by a taxpayer trying to get information. They wanted the complete work product produced under the terms of a contract.
But that's not what counsel recited.
That's exactly what he read. He read that part. That is what the request is. That's what my client asked for. I think it's a little bit, and work product is not a term of art under FOIL. And also, it's really a pretty high expectation to put on somebody who's just an average citizen to be using words that only really have a technical meaning, that are a term of art for litigation lawyers, is what they're really talking about.
Do you have any more questions? Okay. Thank you. People versus McGregor.
Good afternoon, Your Honors, and may it please the Court, Lauren Kober from Debevoise and Plimpton for the appellant Taishi McGregor. We're here today because, in summation, the experienced prosecutor chose to argue that Mr. McGregor had a gun during a shooting when she knew for a fact that was not true. Not only were these statements false, but they also violated the court's order and the prosecutor's own promise not to make this argument. This deprived Mr. McGregor of his fundamental right to a fair trial.
There was an objection when the prosecutor made the statement.
Yes, Your Honor, that's correct.
And that objection was sustained.
Yes, Your Honor.
And it was followed by a curative instruction.
So, Your Honor, there was an extensive sidebar that unfortunately is not captured in the record given the COVID protocols of the courtroom. But during that sidebar, we made clear we were not simply accepting the court sustaining the objection, that we intended to move for further relief, including a mistrial. And at the first opportunity to make that record, which was at the conclusion of summation, we did that. And the curative instruction that Judge Scherzer issued was one that was agreed to before this misconduct to cure the inherent prejudice of allowing in any testimony about May 5th, given our client was previously acquitted of all conduct related to that charge. It was not intended to address specifically the prosecutor's comments in summation.
But didn't the court say things like that summation is not evidence? I mean, it's standard stuff that we do both in criminal and civil trials. Why can't we expect the jury to be able to hear that curative instruction and follow that instruction like they follow all kinds of very complicated instructions?
Well, Your Honor, we specifically asked Judge Scherzer to mention the summation remark when she was giving the instruction that Mr. McGregor was not alleged to have been the gunman on May 5th. And instead, she just told the jury that Mr. McGregor was not alleged to have been the gunman, but she didn't specifically link it to the summation. And given the fact that when she sustained the objection, she did not reference the prosecutor's remarks were improper, they should be disregarded at all at that point in time, we feel that's not sufficient to cure the prejudice from these very extreme statements.
But the curative instructions, they included a reminder to the jury that the lawyer's statements during the summations were not evidence. It included that defendant was not alleged to have been the shooter or possessed a gun on May 5th, 2015, that defendant was not charged with being the shooter on May 5th, and summations are not evidence. Whether that was intended to address the summation specifically or not, the effect is the same, isn't it?
Respectfully, Your Honor, they were not connected. This was a very long jury charge. The people put in a lot of evidence.
Yeah, but the court seems quite specific, right? That with regards to May 5th, the people were not indicating that he was either the shooter or in possession of the gun. So why is that insufficient?
Well, Your Honor, that was the instruction that was going to be given before the prosecutor made the remark about Mr. McGregor having a gun. That was the instruction that was going to be given just because of the inherent confusion of presenting evidence about an incident where a client had previously been acquitted of all conduct. And
I'm sorry, I have one more question. Does harmless error, even if you're correct, how does harmless error play into this?
Well, first, Your Honor, we don't believe this should be subject to harmless error analysis because the right to a fair trial is a right of constitutional proportion. But even if you were to apply harmless error analysis, there's more than a reasonable possibility that this contributed to Mr. McGregor's conviction here. The prosecutor directly argued that Mr. McGregor had a gun during a shooting, and then he was convicted of a conspiracy to possess guns. That went straight to the heart of what he was convicted of, and given the lack of other evidence in this case, it cannot withstand harmless error analysis. And further, this was not some moment of confusion or a mistake as the people would have you believe. The prosecutor here knew these facts. She knew them because this was her second time trying this case. And at the first trial, as previously discussed, Mr. McGregor had been acquitted of all of the conduct related to May 5th, including 2 counts of criminal possession. And so given that, leading up to and during the trial, there were many discussions about what could and could not be said about this shooting. And the court clearly ruled that the people could not point the finger at Mr. McGregor. And the prosecutor clearly understood what that meant. She assured the court and defense counsel before the trial that she would not be arguing that Mr. McGregor possessed the gun and that he was the shooter.
If I may, because you said the lack of evidence, and when you said lack, like a bell went off for me, because, let's talk about the various Facebook messages that he exchanged with the fellow gang members about, obtaining the gun, where he stored the gun, using the gun about rivals. I believe it was like the testimony, I forgot the names right now, I'll look at my notes, but, 007, that means a gun. So let's talk about that evidence.
Sure, Your Honor. So the people are trying to connect this evidence that is just, those are 2 separate things. The cooperator who testified, his testimony was entirely uncorroborated.
Now, I want to add, too, because, I know there was slang in the Facebook messages, right? Food for ammunition, both by Officer LaSalle and I believe it's Ayama, if I'm, pronouncing that correctly. So let's add to that as well.
Yes, so both Mr. Nyama and Detective LaSalle testified that these words have multiple meanings, including their ordinary meaning. Most obviously, the message about getting food, they could have been just talking about getting something to eat. There is no official gang dictionary about what this means, and these messages were not connected to any specific incidents. They were on totally separate days that have nothing to do with the incidents discussed at the trial. They're not connected to each other, although the people try to connect them. They're from different days with different people, and I see my time is up.
Okay, you have time, rebuttal. Thank you.
May it please the court, Alexander Michaels on behalf of the people. First things first.
The prosecutor's statement in summation clearly went against the direction of the court, right? And, well, I see that you may not agree with that, but I'll let you respond to that, but let me finish my question.
Sure.
Let's assume that it went against the direction of the court, and the court issued its curative instruction. Was that enough to remedy any prejudice?
Well, first things first, if I may, first disagree with the initial characterization. Justice Scherzer herself actually said in her written ruling after the 330 papers in this case that the prosecutor's submission comments did not directly contravene any of the rulings she had made. What had happened here was the parties were always focused on the issue of whether he was the shooter. The prosecutor had mentioned before trial that she did not intend to argue that defendant had possessed a gun at all that day. But then over the course of the trial, the parties were so focused on the issue of the shooter still that the defense itself characterized Justice Scherzer's in limine ruling as being that the people were not allowed to argue the defendant possessed a gun that day. And I actually have the page site for that. I think it's A979. Yes, A979. So that was the defense's own characterization of Justice Scherzer's ruling. And of course, the parties remained focused on that particular issue throughout the course of the trial, and that was why the prosecutor was so focused on that particular issue in her summation. Now, yes, she did argue that the defendant had possessed a gun during summation, or she began to make that argument before she was objected to and the objection was sustained, but that did not directly contravene Justice Scherzer's ruling. And then, so the second aspect of your question was about the curative instructions, I believe?
Curative instruction, was that enough to cure any prejudice that may have resulted from that?
Yes, absolutely. Well, what's important to keep in mind is that the objection was sustained in the first place. That sustained objection, of course, instructs the jury that they're supposed to ignore whatever just happened. And of course, if the defense has any problem with the curative instructions not being as compelling as maybe they could have been or not being placed right where they could have been, the defense could have asked for such instructions during that sidebar conference that was off the record. And that feeds into the preservation argument as well. Because if the defense had said in a timely manner during that sidebar, we want a curative instruction right now. We want a curative instruction that explains that there is no allegation the defendant possessed a gun, in addition to there being no allegation that he was the shooter, then that curative instruction could have really timely and effectively addressed the issue. Instead, the defense waited until after the summations to make a mistrial motion, and it got the curative instructions that it wanted in the final charge. And of course, those curative instructions did address the possession issue as well as the issue of whether the shooter might have been defendant. And that's all the relief the defense was entitled to at that point, and it did eliminate.
Was the error harmless, counsel?
Yes, the error was also harmless, not only because the curative instructions eliminated any prejudice, but also because of the overwhelming evidence in this case.
Can we discuss that? When you say overwhelming evidence, I think that term is used quite loosely. What is it here? What's the corroboration for the cooperating witness?
Well, first of all, the cooperating witness did have very detailed testimony about the particular gun the defendant had, 007 gun, they called it, because it was a 9mm that resembled a gun that they had seen in James Bond movies. And the cooperating witness also had very detailed testimony about how he knew that gun belonged to the defendant.
But what's the corroboration to that?
The corroboration includes 3 different text messages, Facebook messages and text messages, that is, in which defendant himself and his co-conspirators are using thinly veiled language to refer to acquiring guns, to refer to using guns against rivals.
Was one when he mentioned that he had a grip and that he was in building 1?
Yes, exactly. There was one where one of the co-conspirators asked him, WYA, where are you at with the grip? And defendant responds, I'm in building 1. And
Now, your adversary says about those that's completely disconnected to what happened on the day of the incident. What's your position on that?
Well, what happened on the day of the incident is actually not that relevant to this particular conviction. This particular conviction is conspiracy to commit criminal possession of a weapon, and that conspiracy spanned multiple years. So whether that has anything to do with the May 5th incident is irrelevant. In fact, it's because the May 5th incident is so irrelevant to this particular conviction that the error was also harmless, because all this other evidence goes to issues that occurred on different dates and goes to different occurrences, such that the May 5th incident and the evidence about it is actually not that important for this conviction.
Did the cooperating witness testified as to the meaning of the words that were used, grip, food, and other things?
Yes, he did testify about that. And he testified specifically about some of these text messages and Facebook messages. Not all of them necessarily, but I think with he's going to call me at 4, he's going to get you all some food with it. The food, I think the cooperating witness specifically testified that that meant ammunition in that context. And then there was also testimony, I can't remember if it was the cooperating witness or Detective LaSalle, about how defendant's statement, you know it's on deck, we got a skirt to the ops, meant that defendant had a gun and he wanted to go attack opponents with it. Unless the court has any further questions, the people ask that the court affirm.
Thank you.
Your Honor, to start where my friend started, the idea that there was a distinction between arguing that Mr. McGregor was the shooter and had a gun on May 5th is just a ridiculous distinction. The prosecutor argued that he had a gun while shots were being fired, and the clear implication of that was that our client was shooting a gun on May 5th. She clearly saw these as one incident, which is why she said she would not be arguing that he had a gun and that he was the shooter. So to the extent that we had been referring to in shorthand the people not arguing that he was the shooter on May 5th, that's because it was all considered part of the same thing, because he was acquitted of all conduct, including 2 counts of criminal possession of a weapon.
Aside from the fact that the court sustained the objection and then gave a curative instruction, did the defense trial attorney request a specific instruction be given to the jury?
Your Honor, it is not correct that the court just sustained the objection and we moved on. There was a very lengthy sidebar, and the court had to cut it off because if you look at, I'm sorry, I see my time is up. Can I continue?
Finish the question.
If you look at the transcript from the next day, the court opened by saying defense counsel has a motion they want to make, and the reason she knew that is because on the record, because when we were off the record at the sidebar, we made clear we had a mistrial motion and we wanted further remedies to be given, and the court said, we're not going to do this right now. I want to finish the summation. We'll deal with this when the summation is over, and that's exactly what happened here.
Thank you. Thank you very much for your public pro bono service in this matter. Law Office of J. Bacher versus Safler.
Good afternoon. To please the court, my name is Nancy Letty-Gurin, counsel for James Bacher, the appellant and respondent on the cross appeal in this matter. The key issue, this has been a 4-year run to try to get a declaratory judgment on the meaning of the operating agreement in this law firm, which is a personal injury law firm, which was dissolved.
Well, let's get to the heart of it, because the trial court found that 3.04, which is the dispositive provision in the operating agreement, is ambiguous. What was incorrect in that determination? Because on one hand, the operating agreement clearly states that all cases revert back to the originating partner, and that's one interpretation. And on the other hand, it states that only cases on Schedule A go back to the originating partner. So isn't there an inconsistency between those two provisions? And how can we resolve that inconsistency as a matter of law without looking to extrinsic evidence?
Okay, I don't think there's an inconsistency whatsoever. The operating agreement as a whole says any number of things. First, it says all cases are partnership cases. It says and it also says that they belong to the partners in general. It makes no distinction between
Well, how do you grapple with the very specific provision that all cases revert back to the originating partner? How do you deal with that language and say that language doesn't have some import or needs to be grappled with in some way in reaching a determination as to what the operating agreement means?
Right. So the 3.04 is a very specific forfeiture provision in the instance of dissolution. And if you look at it, it schedules certain cases that will be considered the property of an originator.
But doesn't that, I assume you're relying on the Schedule A language, why should that provision trump the other sentence? Why should, because it's hard to harmonize those two provisions. How to decide that one provision is entitled to more deference than the other provision in terms of resolving how to interpret the agreement?
Well, the record reflects that the original Schedule A dealt with all cases that were contributed as original inventory of the new firm at the time that the firm was started. And in Mr. Bacher's affidavit, which is in it and in the record, and which was not corrected by Mr. Saffler, it was clear that the majority of the cases were plaintiff. They were all contingency cases, and in fact, it would be monumentally unfair in the instance of a short partnership if the younger non-contributing partner got these cases and they weren't returned if there was a short partnership. So they agreed that to the extent that they contributed, and if the firm was dissolved, that with respect to these scheduled cases, they would get them back. Those cases that were scheduled would revert back to their originators. And they were specifically named, and they were specifically identified.
Wasn't there also a requirement of a yearly revision of Schedule A, correct?
Excuse me?
There was a requirement of a yearly revision of Schedule A?
They also agreed that if there were cases that were originated that they wanted to keep for themselves, they would agree to schedule them. And if they were scheduled, they would be forfeited in the instance of dissolution.
Thank you. You have time to rebuttal.
Okay.
Thank you. Good afternoon, Your Honor. Joel Simon from Smith Measure for the cross appellant Saffler. I'd like to correct a statement that the court made just before. The agreement did not state only the cases of Schedule A go back to the originating partner. That was an error by the lower court. There is no such language in the agreement that says
Isn't that what
only.
we're trying to decide? Isn't that exactly the issue we're trying to decide now?
Well, if you look at the agreement, it doesn't say only. The verbiage, only the cases of Schedule A go back to originating partner, is not in the agreement. The lower court said, we have a conflict here because you got one sentence that says all cases revert to the partner who brought the said case into the partnership, and we have a provision that says only the cases
I'm going to
Schedule A.
ask you to deal with the exact language since it's in front of me. It says, at the time of execution of this agreement, Schedule A attached hereto identifies those files in the firm at the inception of the partnership to be revised yearly, and who would retain said file if the firm dissolves. So it's not just talking about the inception. It envisions that there's going to be a Schedule A, which is going to be yearly revised, and when the firm dissolves, we're going to go look to that Schedule A to determine who gets which case.
But it doesn't say only the cases listed in the Schedule A, and that's an important point. For example, Your Honor, assuming the agreement is updated every year, say December 31st, what happens on February 1st? 3 cases have been brought into the office. The firm dissolves at that point. It's not due yet for the next year's update. Do those cases
Well,
go into the abyss?
that would be an argument for the few cases that happen after the yearly update, but it wouldn't apply to the rest of the cases.
But that's the point, Your Honor. The clear purpose of Schedule A was to avoid disagreements, to avoid the need for an arbitration.
Then let me ask you something, because there's another provision in the operating agreement which I think supports the other side and creates further ambiguity. All matters that are assigned to whatever partner brought in said matter shall be entitled to said file at dissolution, regardless who works in said file. So this clearly suggests that there's going to be some kind of assignment during the course of the partnership, and that if it is assigned, that person shall be entitled at dissolution. So doesn't that support that the import of the Schedule A, that you have to actually have an assignment occur before the dissolution to be able to claim a right to that case?
Again, Your Honor, Schedule A was a means to an end. It was, let's not have any confusion, let's not have any question whose file this is. If we do have a question that we can't resolve, then it goes to arbitration. The problem is that, unfortunately, Schedule A wasn't done yearly. They both forgot all about it. It wasn't done.
So doesn't that create an ambiguity about what we should do?
No, Your Honor.
Why doesn't that create an ambiguity?
Because otherwise, what is the purpose of the arbitration? It's where we don't know whose file this is.
Why couldn't
That's
theoretically...
because it's not in Schedule A.
Why couldn't theoretically the arbitration apply to those cases which happen after the yearly update? But the scenario you gave us earlier, where there's a period in between...
That would be one use of it. But since it doesn't specify that, it's clearly for any case where we don't know or we don't agree
Then why is there a
who
whole
originated
Schedule
it.
A? How, if we
Because they
accept
wanted to avoid that, Your
If we
Honor.
accept your interpretation, how do we give meaning to the language about Schedule A?
It does, Your Honor, because
and give meaning to what you're suggesting.
Your Honor, we'd like to avoid an ambiguity. We'd like to avoid the need for an arbitration. So let's use a Schedule A. But if we don't do it, or cases don't get put into it, that's when we're going to have a disagreement. If it's in Schedule A, obviously there's no disagreement. Where else are you going to have the disagreement, i.e. if it's not in Schedule A? That's where, if we can't otherwise agree, we go to an arbitration. It otherwise renders the use of the arbitration pointless. Also, as counsel wants to utilize the entire agreement, we agree. Go to 3.05, which also states for purposes of dissolution, all cases go to the originating attorney. That wasn't in the underlying papers. I know counsel is going to bring that up, but it was the point, their point, that you need to look at the contract as a whole. I agree. Look at the contract as a whole, see 3.05, see 3.04. That's the purpose of the agreement. Thank you, Your Honor.
I think it's quite clear that you look at the contract as a whole. He gave Mr. Backer an interest in the firm, and he said, work for it. Every year, as you work harder, you'll get 10% more of the firm. And now he says, except if I call a dissolution, which he did, I can take it all back by saying, now I'm going to claim I originated all these cases.
Out of curiosity, how would that impact on, say, if your client had worked 90% on a case that was originated by the other side? How would that work as a practical matter once there was a settlement or with respect to the proceeds of those monies? Would your adversary be entitled to 100% of it?
No, what happens is the law firm, when the case dissolves, the law firm, no matter who it goes to, has a quantum merit interest in a case that has a...
In other words, you would have a charging lien on all those files.
And he has, and Mr. Backer and Mr. Safler have their partnership interest percentage in that lien. And so Mr. Safler should be winding up, getting the firm its fair share, whether it's 10% or whatever the quantum merit interest is, and then sharing it with his partner. But that's not what's happening. He's deciding retroactively that all the work that Mr. Backer did has just been, has disappeared, because now in dissolution, which he called unilateral, that all that work is no longer counts. Now, if he had told Mr. Backer while this was going on that he wanted to call this particular case that came in as an exception that he would not share in if they dissolved, Mr. Backer had a choice.
Thank you.
Say,
Thank you very
okay,
much. Thank you.
Okay.
Your Honors, respectfully, the main question here is...
Can you respond to the question which I posed to your adversary? What happens in the instance the case goes back to the originating partner, but the other partner has done the bulk of the work? Is the fee forfeited, or the quantum merit fee forfeited?
Per the agreement, Your Honor, yes. The agreement specifically states...
Doesn't that smack of unconscionability? And how does that comport with our ethic laws with respect to being compensated for work that's performed?
Your Honor, if you look at the Court of Appeals case of Denberg as well as Cohen versus Lord, they all deal with scenarios where money is taken from the other partner, where there's a restriction on employment, not in situations where it's unearned, unrealized income. And that's the distinction. This is unearned, unrealized income. We all work for law firms. I do work on another partner's file. I don't have equity in that file.
It's unearned because...
There's been no settlement. There's been no verdict.
In other words, a lawyer can do 90% of the work, goes back to the originating partner, and the originating partner gets $1 million, and although the other side did the work, they're not entitled to a penny. That's your position?
Per the agreement, yes, Your Honor. That is the language of the agreement which the courts have held is appropriate as long as you have a partnership agreement which spells that out, which this does, Your Honor. Thank you very much.
Thank you both very much. RKB International, I'm sorry, wait. Garrett versus City of New York. I knew that was wrong.
Good afternoon, and may it please the court. Chloe Moon on behalf of the City of New York. Summary judgment should be granted to the city for two primary reasons. First, the jury would be required to speculate as to the cause of plaintiff's fall, and liability cannot rest on conjecture. Second, even if plaintiff had sufficiently identified the cause of her fall, transit would be responsible for that defect. That's because there's no question that this fall happened within. Let's
talk about that.
Yes, of course.
The second issue, which is who's responsible for this area. I know there's a recent Second Department decision from Fajardo, which finds that the city is the owner. And when you go to look at the relevant provisions of the lease does seem to indicate that the city is the owner of the grate, not the transit authority. So since the statute puts the obligation to maintain the grate on the owner, why isn't the city responsible under the law?
So a couple of responses to that. First, we think Fajardo is an opposite here, in part because in that case, transit had specifically established that it had not caused or created the defect here. That hasn't happened here. Second, we think it's not binding here on this court. We think that the decisions.
I think my colleague is asking beyond Fajardo, just in terms of doing the analysis based on the lease provision at issue here, which is section 2.1.
Yes, and I think I understand the question that is, are you an out-of-duty landlord? Which, yes, but...
Right, but we're not talking, I mean, under the common law, that's the analysis. Are you an out-of-possession landlord? But here we have a specific statute that's somewhat akin to the sidewalk statute. If you own the premises, you are responsible for the sidewalk. Even if you're an out-of-possession landlord, you have the ultimate responsibility. And this appears to be a similar statute, which says that if you are the owner of the grate, then you are legally responsible for the grate and 10 inches out from it. So why wouldn't that apply in this case to result in an outcome that the city is responsible?
So we think what the lease is doing is displacing the city's responsibility. The lease, the purpose of it is to do exactly that, which is to say that the subway system and its facilities and its property is the responsibility of transit.
But respectfully, yeah. I would look at the exceptions for 2.1. You're very specific. You say the city hereby transfers title ownership of materials and supplies, not property. So property, i.e. the grate, is still your grate. They acknowledge in their brief that they're responsible for the grate, but they say the accident didn't quite occur on the grate, and there's an issue as to your responsibility. Why isn't that a correct argument based on the lease, putting aside the issue of what Fajardo says?
Your Honor, the lease actually does say any other materials, supplies, and property incidental to or necessary for the operation of such transit facilities. That's at R311. So it does include that property as well. And I think just to explain the logical limits of this argument.
The part that you just read, is that where the lease reads that the city hereby leases or the city hereby transfers? Because the remainder of those two sentences differ.
Matters. Yes, so it says the transit facilities now owned or hereafter acquired or constructed by the city and any other materials, supplies, property incidental to or necessary for the operation of such transit facilities.
Right, so the transfers refers to the materials and supplies, where the lease refers to transit facilities, material supplies, and property.
But again, I would also say that materials and supplies are included in the ventilation grading.
Are you saying that a grate is material and supplies?
I would, yes.
So it was a material before it became a grate. Once it's a fixture, you're still saying it's a material?
I am, Your Honor. I mean, ultimately, the purpose of this lease is to transfer this responsibility. I think there's.
Well, I agree with you. It is to transfer responsibility, and the Transit Authority acknowledges that it is responsible for the grate, but you're still the owner. You're still the owner of that property because you did not transfer that aspect of it.
I mean, I think the problem is, if that were true, that would make the city liable for the subway steps, for the platforms, the ladders.
Isn't the distinction, though, that in this case, we're talking about a specific statute that deals with grates, just like there's a specific statute that deals with sidewalks. And if we're dealing with some other aspect of the subway system, then you have all the arguments about out-of-possession landlord and who is responsible. The only reason this case is different, or is arguably different, is because we have a specific statute dealing with grates.
But I think the rules and regulations, I mean, that's the section 2-07, that as a regulation is distinct from the analysis that happened in Fajardo about the administrative code. There's also a distinction there, and I think what we're ultimately looking at is those rules and regulations, as well as the administrative code, are intended to take liability off of the city where there's somebody better suited to do that kind of maintenance, and that's transit in this situation, and that's what those rules say. Thank you so much.
May it please the court, Yolanda Ayala for Transit. Based upon the questions, I'm not going to go too far. I agree with everything that the court has said.
Well, we're not saying anything. We're just asking questions. We're not coming to any conclusions whatsoever.
Understood, Your Honor. Materials and supplies are not defined in the lease. You know, the city drafted this, so if there's an ambiguity, it goes against them.
Oh, so what about the concern raised by adversaries that if we were to supplement the reasoning of Fajardo, that there would be unlimited liability on the part of the city? Is that a fair statement?
No, I don't believe that at all. First of all, everything that they're arguing now was considered by the Second Department in Fajardo, and you know, they correctly looked at the statute, looked at the similar abutting landowner statute, and it says if the legislator wants to include owners or leasees or out of possession owners, they can include it.
Well, let me ask you about the indemnification provision, which is not something that was addressed in Fajardo.
Correct.
Why is the city, assuming they are responsible because they are the owner, why aren't they entitled to indemnification?
Right, because the way the indemnification clause reads, it says we have to indemnify them for accidents arising out of the operation, management, and control of the leased property. In this
Which would
case,
include the grate.
correct. However, Your Honor, in this case, it's undisputed. Typically, the grates have a concrete border around it. That wasn't the situation here. Here you had a grate with hex pavers around it. And it's undisputed that the city installed those hex pavers. If there was an issue with the pavers, the city would repair it. Transit doesn't even have access
It's the
to
Parks
hex
Department's
pavers.
responsibility, correct?
I'm sorry?
It's the Parks Department's responsibility with regards to those pavers?
Correct. So in this case, it's not because of the operation management of the grading that caused the incident. It's the sinking of the pavers.
How do we decide that it's a matter of law what caused the accident, whether it was the grate versus the pavers?
I may not necessarily disagree with that, but they want summary judgment.
Well, you in your brief, you say they're issues of fact.
Correct.
So that's your position.
So you're saying we can't decide one way or another whether it was the grate or the pavers, and it was the pavers that caused the accident, then there would be no indemnification.
Right, but certainly they're not entitled to indemnification as a matter of law under these circumstances. If there's nothing else, I'll rest on my brief.
Thank you.
Thank you.
Just to respond really quickly to what was just brought up, just because there wasn't the typical concrete border, that's not really dispositive in this case. The rule applies to a 12-inch perimeter. It doesn't
Well, there's
apply
two
only
different
to-
issues going on. One issue is the statute, which brings in liability for the grate in 12 inches. But the indemnification is really a separate issue because that's not in any way governed by the statute. So there you have to look to the indemnification. So you could come out with different results on the two issues. What's wrong with what I'm saying, I guess?
You're right that we could, but I think under both, it's clear that the city is not liable here.
I don't understand. Why is that?
Because
What about let's make it more specific.
Yeah.
There's a question as to whether or not the pavers caused the accident. If the way that the pavers were put in caused the accident, why wouldn't the city be responsible for that?
Well, and I think that's because what we're pointing to here is the inspection that says that the city is doing all these replacement of the pavers. It's not doing the 12-inch perimeter around the grading because that's the
apples and
responsibility
oranges,
of
because now we're talking about indemnification. We're not talking about who's initially responsible for the grade in the 10 inches. We're talking about whether the indemnification provision, which has nothing to do with the grade law, it's a completely separate thing, whether or not this accident was caused by something that comes within the scope of the indemnification.
Right, and we believe it does come within the scope. It rises out of the control of this area, specifically next to the subway grading.
But the testimony is that there was settling, which essentially caused the grading to be raised. Plaintiff alleges to have tripped over that raised grading. It seems to me that there's an issue of fact, whether it's the city's failure to maintain the hex blocks.
And I think, again, because the liability here is for transit, for that 12-inch zone, that's what allows indemnification for the city here. Because
The 12-inch
transit
zone is based on what?
is based on the rules, on section 2-07.
But if it's your property, wouldn't that be your responsibility?
Well, we don't think so, Your Honor, but
Thank you very
thank you so
much.
much.
Okay. IKB International versus Wells Fargo.
Good afternoon, Your Honors, and may it please the Court. Michael Marcucci from Jones Day on behalf of the appellants here. Under CPLR 202, the question of where claims accrued for an economic injury is an economic question. And IKB has been very specific in this case about the damages that it is seeking.
Well, let's go right to the bright line rule, since there's been an indication from the Court of Appeals that they rather us apply a bright line rule rather than a multi-factor test, and they were pretty explicit in stating that. Why wasn't it correct for the court to find that the Ireland statute of limitations should apply under the borrowing statute based on the bright line rule that you look to the residence of the assigner to determine which state or which area should apply? And in this case, because of the unusual procedural posture, at the time of these claims, the assigner was in Ireland, not in Germany.
So we are not advocating a multi-factor test. And the bright line rule is the statute of limitations applies where the injury was felt.
Well, what about the bright line rule about, because that's the first part, where the injury is felt. But then to determine where the injury is felt, it seems like a lot bright line rule has been established that you determine where the injury is felt by looking at who's the assigner and who's the assignee, which is like a subset rule. So why wouldn't we apply that bright line rule in this?
Because the first bright line rule still applies. So you have to then look to who is the assigner and where was the injury felt.
So who's the assigner in this?
The assigner here is Rio, and when Rio, because of the nature of the relationship between Rio and IKB, when Rio as the assigner was the holder of these certificates, it was IKB in Germany that felt the injury.
So you're saying that Rio didn't suffer any injury in Ireland?
Rio did not suffer the injuries that IKB is seeking.
Any injury? Did
Well,
Rio suffer an economic injury in Ireland?
Not the injuries IKB is seeking here. It's possible, I mean, the way
Well,
Rio is
as the
structured.
holder, wasn't it entitled to the distributions at the time? Whatever it had to do with them, wasn't it entitled to them in the first instance?
In the first instance for an instant.
Well, it received principal and interest payments, right? So wouldn't that be a basis to look to see whether or not there was injury?
They received them and they passed them through. So the injury that IKB is seeking to redress here are principal and interest payments that would have always gone to IKB in Germany.
But the value of the certificates, where do they appear? Do they appear on Rio's balance sheets or elsewhere?
Both. I mean, Rio is consolidated into IKB's financials. And so
Let's ask about a separate question from the residence test. What about our recent case, MLRN, where we, the First Department, specifically held that the relevant injury for statute of limitation purposes is where the certificate holders received the underpaid waterfall distributions. And in that case, there's no dispute in this case that would be Ireland. So why isn't that case controlling on us?
well, MLRN was also my case, Your Honor. And
So how are you distinguishing it?
well, there the trial court applied a multi-factor test to find that New York law applied, and this court overturned it. And there was a fact question about whether the principal place of business of the underlining assignor or the place of incorporation of the underlying assignor would control for statute of limitations purposes.
How are you distinguishing the actual holding of our case?
I'm distinguishing by the
Which seems to apply here.
Well, it applies, but you still have to look at the specific facts. So here, factually, just like in the Equifirst case, where Justice Chan did not apply the residence of the assigner because based on the structure there, the economics of that transaction, the loans are just passing immediately through. Here, the principal interest payments that IKB is seeking to recover, we've established factually would have only gone to IKB AG. Rio had no.
It was a pass-through, essentially.
It was a pass-through. And again, Judge Kodal in the Southern District, with another special purpose vehicle that was designed to reorganize another failed German bank that went bad during the financial crisis, found there the entity was called Phoenix Light instead of Rio, found there that the German underlying beneficiary, the residence of the German underlying beneficiary, was where the claims accrued, not where the indenture trustees of the special purpose vehicle resided.
That kind of sounds inconsistent with our recent holding in MLRN Bank, no?
I don't think so, Your Honor, because in MLRN, there was no pass-through, right? The underlying hedge fund, it was either going to be their principal place of business or this incorporation. That hasn't been resolved yet. Here, because of the structure of Rio, which everybody agrees was set up for the purpose of IKB, whose only job was to pass these payments on through to IKB.
I don't think everyone agrees. I think there's a sharply disputed version of what its role was or wasn't.
I don't think so, Your Honor. I think if you get past the brief and you look at the record, IKB's corporate representative here admitted that the purpose for Rio was set up to benefit IKB. And that's what their representative.
It was created as a separate entity with its own financials, its own corporate structure. I mean, the formalities were followed in terms of creating a separate structure, and they chose to create, even if they controlled it, they chose to create this separate structure in Ireland and not in Germany.
But they kept all the.
That was the decision.
That was the decision, but they kept all the money in Germany. So we have a case here where.
Where was the money paid? It was paid to Rio in Ireland.
Well, it probably first went to their trustee bank, which is BNP Paribas, and then passed through to Germany. But the only people who could hang on to it were in Germany. And if IKB recovers in this case, the money will be in Germany as well.
Thank you.
Thank you, Your Honor.
If it pleases the court, John McFerrin Clancy for the IKB plaintiffs. Your Honor is exactly right. The Bright Line Rule.
Again, we're not holding anything. So
No. But we're speaking about a Bright Line Rule that this court stated in MLRN, right? Which is the injury takes place for borrowing purpose statutes in an RMBS case where the money should but wasn't paid to the certificates.
But let's just push back on that. Your adversary says that it's just a simple pass-through, that in fact Rio had no losses. If that were correct, which I'm sure you dispute, wouldn't Germany be the correct place? Or would you still say that it's Ireland, even though there was no economic loss felt in Ireland by Rio?
Well, I think when you look at other contexts of so-called pass-through entities, a wholly owned subsidiary, for instance, where all the losses that hit the subsidiary are going to be felt by the 100% shareholder, as you saw in the IKB versus Bank of America case, the subsidiary's residence still applies. In a case of a trust, right, another pass-through entity, as you saw in Deutsche Bank versus Barclays in the Court of Appeals, it's the trustee's residence again that dictates, right? So even in the case of a pass-through entity, right, the courts have consistently said, well, we're going to look at who's going in a representative capacity here, right? So I don't think that even if there were, quote unquote, no losses, that would be an issue. I think the other problem is.
But before we go further, did in fact Rio suffer economic loss in Ireland?
Yes, in two senses, Your Honor. First, as the court's already noted, Rio was its own entity, own books, records, et cetera, and it had its own bills to pay. It didn't just have the obligation to pass on the proceeds. It had to pay the security administrator, the custodian bank, et cetera. And it was not bankruptcy remote. It ran, as the lower court found, a risk of insolvency. So when it didn't get paid on certificate, if the certificates at all come a cropper, it wouldn't be able to pay its own bills, and it would be at risk. So it recorded the losses on its own books,
So it did post a decline in values on its books?
Yes, oh,
Is that a
yes,
loss? Is that for purposes of the statute, is that an economic loss in Ireland?
Yes, I think it clearly is. As this court, I think the MLRN case, and to go beyond MLRN, which I think, first let me just finish off on loss. The statement the council keeps making, it all went to Germany, isn't true, because IKB was not the only creditor, right? The mezzanine lender was Lone Star, which is a Luxembourg entity. The Luxembourg statute is 30 years. So
And that's why you're arguing the multi-factor shouldn't apply because it gets complicated.
exactly, Your Honor, right? What's interesting is let's look for, the court has created a very clear, very easy to interpret rule for where loss occurs in an RMBS case. And even though these cases that are relied on by defendants came earlier, they follow the same
So in
reasoning.
this case, if there had never been an assignment back to the plaintiff in this matter, then it would have been Germany's statute of limitations because that company would have remained the assigner rather than the assignee. Would that be your position?
No,
Because
I think that, well, I think
originally it was IKB that was the assignor before Rio then assigned it back.
right, but I
If we
think
applied that, like, in that case, we had that case before us, would you be still taking the same position?
actually, again, Your Honor, I think if I can just unpack this and look at a couple of the cases at defendant's site, you'll see that this is already resolved by the holding in MLRN. Question, the relevant residence is where the certificates should have been paid but weren't. Now, in Deutsche Bank versus Equifirst that they talk about, what happened there? The trustee tried to claim, oh, don't use my residence, use the residence of the depositor, right? The entity that first took the loans because it was in a better jurisdiction for limitations purposes. But the court noted there that there was a simultaneous transfer from the depositor to the trustee of the loans. So as the depositor said in that case, it was in the record, noted in the decision, it never even took possessions really of the loan. So there was
Let me ask you a completely unrelated question just before the time passes. Are you still taking the position that we shouldn't be looking and comparing New York statute of limitation under the Bronx statute, or have you conceded that point?
I'm sorry, the New York statute to the...
Are you still taking the position, or are you taking the position that we shouldn't, assuming that you're successful in your argument that the Ireland statute of limitations applies, are you still taking the position that we shouldn't be comparing it to the New York statute of limitation and applying the shorter of the two?
I think the showing was that the Irish limitations period is no longer than New York. And so I think that's...
Well, didn't the court never make that determination? Because the court below decided that the Ireland statute of limitations applied, so it never did do an analysis comparing the two statutes. Are you objecting in any way or saying that if we agree with you that the Ireland statute applies, that we shouldn't remand it for that comparison to be done?
I think the showing on the record was that the two were the same. So,
That's not what the court...
So we're...
Counsel, that's not what the court found, right? Correct? And in fact, didn't you actually cross-move for
We did,
relief, saying that it should be New York law? So if we agree with you, why shouldn't there be a remand to consider New York statute?
We wouldn't really have an objection to that, Your Honor, right? If we want to take a deeper dive into the comparison between Ireland and New York, we're pretty content with that. But I want to say again, I keep trying to get it out, I'm sorry, but even in Phoenix Light, the key consideration the court had there was that it was the indenture trustee that owned all rights to the certificates during the time when the losses occurred. In Equifirst, the key to the court's determination was that the trustee and not the depositor had their certificates and all the rights at the time the losses occurred. This is the MLRN rule. This is the bright line rule that applies in every context. Excuse me. As a result, when you look here, remember what we're suing on. Rio purchased outright, lock, stock, and barrel, these certificates in 2008. We brought this lawsuit in 2015 based on a 2012 assignment and a 2015 assignment. In other words, while Rio was fully in possession of all rights, owned their certificates, and took the losses for 7 years, that's the bucket of claims that we brought suit on.
Thank you.
Thank you, Your Honor.
just starting with the Ireland point, obviously we agree that the court still has to compare the New York statute to the Irish statute, and
that's your alternative relief.
that's right, Your Honor, in the context of the particular claims and when those specific claims accrued. But just a couple of points from the record as to what IKB's corporate witness admitted here about the losses. Now, he admitted at record 1576 that the transferred securities were still on IKB's balance sheet, that the assets of Rio were consolidated with IKB. He agreed with the question that economic ownership was not transferred to the SPV. And so our main point here is that this bright line test is an economic test. You have to look at economic reality. And in light of the policies of 202, which is both certainty and to avoid forum shopping, having an economic test makes the most sense rather than a formal test, because it's harder to game economics, right? People want their money. So if you look at how the money flows in any transaction, and when you have a special purpose vehicle, it's going to be different than a corporation. It's not the same as a wholly owned subsidiary where we respect corporate formalities. This is not a separate corporation. It was a separate entity. It's not like a subsidiary. It is a contractually based. They were contractually obligated to pay it out. And what we know from the record and what is undisputed, that the actual damages they're seeking, the extra principal interest payments, that would have come through what we call the equity kicker, this extra money after the loans had already been paid off. Nobody took any losses on this, right? The RMBS outperformed the price at which they were purchased. So the money that IKBAG is seeking here, 80% of it would have always gone to IKBAG, and then after 2014, 100% of it would have gone to IKBAG. So contrary to the trial court's decision, this does provide an approach for forum shopping when you have sophisticated entities who can park assets in a more favorable jurisdiction to get advantages of that, even if all of the economic benefits flow back.
That sounds a little speculative to me. That's what's going on between sophisticated business people.
I don't know that's what happened here, but it certainly provides a roadmap for sophisticated parties in the future.
Thank you.
Thank you, Your Honors.
Vargas versus Department of Education.
Good afternoon, Your Honors. May it please the court, Daniel Dugan for the appellant, Mr. Wilfredo Vargas. Mr. Vargas was a probationary English as a second language teacher who was terminated in bad faith just a month after he was observed an unconscionable 20 times by his supervisors within a 2.5-month period of time. Looking back, this was Mr. Vargas's fifth year as a probationary employee. He'd signed a 1-year extension of his probationary period.
And he did that willingly, didn't he?
Yes, he did. But if he didn't sign the agreement, he would have been terminated. Each of the previous...
Where is that in the record? That if he didn't sign the agreement, he would have been terminated?
It's common practice with the Department of Education. The only way to continue as a probationary employee, if you're offered an extension, is to sign the extension. Otherwise, you will be discontinued.
So he would have been fired. And was there any cause for them to have fired him if he had not signed the extension?
Yes.
And what was the cause?
They would have, at that point, terminated his probationary employment.
So they're giving him further opportunities to improve his teaching. Would that be a fair
Well,
statement?
they gave him further opportunity, yes. But when you look back at those years of teaching, he was an effective teacher in each of those school years on his annual professional performance review.
But he's a probationary employee, and we're kind of stuck with what we got. So you have to show some sort of constitutionally impermissible violation. What is that in this case, other than he wasn't sufficiently doing plans, et cetera?
Right. So this court has held previously that it is bad faith, and the discontinuance should be vacated if the Department of Education fails to follow their own rules and procedures, specifically in regards to teacher observations and ratings. Here we have that. Like I said, Mr. Vargas was a successful teacher in each of the school years. His overall rating was satisfactory or effective. There were no overall ineffective ratings. Going into that final school year specifically, a teacher, and this goes for any teacher at the DOE, you make a choice. You have two options as to how you're going to be observed throughout that school year. You can choose 3 informal observations and 1 formal observation, or you can choose 6 informal observations. Mr. Vargas made his choice, 1 formal observation, 3 informal observations. Instead, he's put on a coaching plan. Again, you're putting an effective teacher on a coaching plan, which now the DOE uses as an excuse for his supervisor to spend 20 class periods in his classroom over a 2.5-month period.
Let me ask you, what does that mean, bad faith, though, then? If they're a probationary employee, which means they can be terminated for any reason or no reason, is a dispute about whether they were or were not an effective employee the standard for bad faith? Because wouldn't there never then be a case of bad faith, because there would always be arguments back and forth as to whether they were effective?
I understand, but here the DOE is giving a reason. So they can't fall back on that they don't need a reason. And this court has previously...
Well, they don't need a reason.
They don't need a reason, but they have set out a reason as to why they were terminating his employment. And this court's previously held in Comel, Gupta, Smith, that when they don't follow their own rules, that's evidence of bad faith. Here we have comments that were made by the supervisor. I didn't hire you. I wouldn't have hired you. I'll discontinue you. You also have the background that Mr. Vargas had previously challenged through the grievance process a previous observation, which got overturned by an arbitrator just at the end of the previous school year, so the school year he was terminated in. So now, under the guise of a coaching plan, and we see in the record what other coaching agreement plans look like, they're not an opportunity for your supervisor to stand in your classroom on 20 different occasions, obviously put you under stress, and nitpick, and then use it as a reason for your discontinuance. The other coaching plans, they had modeling from other teachers in which other teachers taught that lesson in front of the probationary employee. They had meetings where they co-planned lessons and worked together. Implementing and using it now as saying it's coaching and we're helping him, it was just an opportunity and bad faith, as this court's recognized previously, to use this as a guise for his supervisor to observe him on an astounding number of occasions and not giving him a chance to correct his mistake. Thank you.
May it please the court, Lorenzo De Silvio on behalf of respondents. With the court's permission, I'd like to make a handful of quick points, just illuminating the factual context of some points that my adversary just made. So certainly Vargas alleges that there were 20 times that he was observed in a period between October and December, but 15 of those times took place after he agreed to enter into the coaching plan on the 23rd of October. So I just wanted to underscore that factual.
Was that communicated to him when he entered into the coaching plan, that he would be evaluated practically on a weekly basis?
It was not explicitly said so, but it did provide that evaluators could come in and look at his progress to make sure that he was meeting the progress that the coaching plan was designed to provide him with. But even setting that aside, Vargas's central theory is that this assistant principal, Rivera, had it out for him, even setting aside that he alleges comments for the first time in reply not in his petition. There's a bunch of problems with that, including the fact that other evaluators evaluated him as well, noting the same issues as Rivera did. There's nothing to connect these statements made 5 years before the superintendent made an independent determination about the discontinuance of Mr. Vargas's probationary service. And then on the Cormel case, we've already distinguished it. That was a case where an administrator was saying, we're going to hold this against you, but it patently belied by the evidence of the observations and evaluations. Here in contract, we have contemporaneous documentary evidence knowing the recurring issues with Mr. Vargas's performance.
Wasn't he also given at least 2, I think, effective ratings?
Yes, I think
What is that? So what's the import of that?
I think it underscores that the only inference on this record was that we had a good faith basis to terminate him, but even putting it aside, we treated him fairly. We could discontinue his probationary service for any reason or no reason at all, and Mr. Vargas has not shouldered the burden of bad faith here. We hope this court will affirm, and we hope the court can do so both with respect to this appeal and the appeal for the denial of the renewal motion. It could save judicial resources for all the parties and the court if they could be resolved that way. Thank you.
Thank you, Your Honors. In regards to the previous effective ratings, there is a system in place, it's collectively bargained, as to how these overall ratings are calculated. For the DOE, as they said, oh, other individuals highlighted deficiencies or things of that nature. Of course, a probationary teacher is going to have some deficiencies and some areas of improvement in observations over a course of years. But at the end of the day, the final, say, grade, if you were a student, was effective or satisfactory. That's like saying I got an A in a class and cherry picking the questions I got wrong over the years to tell me I'm now an ineffective teacher and you're going to terminate my employment. Overall, under their own system, he was rated an effective teacher each of the years. They failed to follow their own rules and procedures in the final half year he was given of his employment and terminated him in bad faith. And we request reversal of the lower court's decision. And I believe a motion was made to consolidate the two appeals because they are the same.
The board a separate appeal of the,
There's a motion for reconsideration, renewal, and
there
the
was an
court
appeal
decided
of
it
that?
was unnecessary for us to make that motion, and I believe they're both consolidated to that.
you both think that both of those appeals are consolidated before us now?
I don't believe they are consolidated, but they involve substantively the same issues. So
And when
rather
is
than
the other
reviewing
one
again,
counted
it's the-
for or
I
on?
don't believe it's counted. I don't believe it's been perfected.
There's the
So how
one,
can we decide it if we don't even have it yet?
on the calendar, there, in parentheses, it is 2, and then we were asked to submit a supplemental record before today. Both decisions are in the
Okay,
record.
I'll look into it. Thank you.
Thank you, Your Honors.